Next page. 5. Legal and contractual capacity. 5.1 Legal capacity. All persons, natural and juristic, have legal capacity, meaning they can bear rights and duties. This passive capacity stems from legal personality and is not dependent on age or status. Example: an infant, child under 7, can inherit and acquire rights/duties under a contract concluded by their guardian. Capacity to act, active capacity, varies and determines if a person can create, alter, or terminate rights/duties through juristic acts, for example, executing a will, concluding a contract. Active capacity depends on legal status, including age and mental competence. Law grants full capacity only to those who are sane, sober, and mature enough to understand the nature and consequences of their actions. Infants have no capacity to perform juristic acts. Let me know if you need further details or if I should proceed with summarizing the next sections. Next page. Study notes. Contractual capacity. 5.2 Contractual capacity. Definition: the ability to create rights and duties by concluding a contract. Subset of juristic capacity. Since contracts are bilateral or multilateral juristic acts, contractual capacity is part of the broader ability to perform juristic acts. Depends on will formation. A person must be able to form and express a legally relevant will to contract. Varies based on status. Capacity depends on age, mental competence, and legal status, for example, insolvency. 5.3 Natural persons. All natural persons have passive legal capacity. Their contractual capacity depends on their status, which is influenced by age, mental competence, and financial position. 3 categories of natural persons. 1. Persons without contractual capacity. 2. Persons with limited contractual capacity. 3. Persons with full contractual capacity. 5.3.1 Persons without contractual capacity. Persons who cannot appreciate the nature/consequences of their acts lack contractual capacity. Examples: infants under 7 years cannot perform juristic acts independently, but can hold contractual rights/duties through their guardian. Severely mentally ill persons must have proof of incapacity. Court order serves as prima facie proof. Severely intoxicated persons only lack capacity if they were unaware of entering the contract or its terms. Mere impairment is insufficient. Legal consequences. A guardian may contract on behalf of an infant only for estate management, maintenance, and support. Some contracts, for example, engagements, cannot be concluded on behalf of an infant. Burden of proof rests on the party claiming another lacked capacity at the time of contracting. The Consumer Protection Act voids contracts where a supplier knew or should have known the consumer was declared mentally unfit. 5.3. 2 Persons with limited contractual capacity require consent or assistance from another person to conclude contracts. The assistance supplements their inadequate judgment. Would you like me to continue with subsections 5.3, 2.1 to 5.3, 2.4, or make any adjustments? Next page. Contractual capacity. Study notes. 5.2 Contractual capacity. Definition: the competence to create rights and duties through a contract. Requirement: capacity depends on the ability to form and express a legally relevant will. 5.3 Natural persons. All natural persons have passive legal capacity, but contractual capacity varies by status, for example, age, insolvency. 3 classifications. 1. Persons without contractual capacity. 2. Persons with limited contractual capacity. 3. Persons with full contractual capacity. _ 5.3.1 Persons without contractual capacity. Infants, children under 7 years old, cannot independently conclude contracts. Can bear contractual rights and duties if a guardian acts on their behalf. Guardians may contract only for estate administration, maintenance, and support. Certain contracts, For example, engagement cannot be concluded on behalf of an infant. Mental incapacity. A person is presumed mentally competent unless proven otherwise. Burden of proof is on the party alleging lack of capacity. Court-ordered mental health care. Court order serves as prima facie proof of incapacity. Burden shifts to the party claiming capacity to prove otherwise. Contracts by mentally unfit persons. Void if supplier knew or should have known about mental incapacity. Consumer Protection Act. Supplier cannot argue that the contract was concluded in a lucid interval. Intoxication. Affects contractual capacity only if the person did not understand they were entering into a contract. The person was unaware of the contract's provisions. Mere impaired judgment is insufficient to void a contract. Contracts concluded in such a state are void ab initio, invalid from the beginning. Burden of proof lies with the intoxicated person. 5.3. Two persons with limited contractual capacity require assistance or consent to conclude contracts. Consent supplements their inadequate decision-making ability. 5.3. 2.1 Minors, ages 7 to 18, general rule, cannot contract without guardian's assistance or consent. Types of consent. Given before or at contract formation. Given afterwards, ratification, validates the contract retroactively. Court can override guardian's refusal or set aside consent. Emancipation. Definition: a minor acts independently in certain transactions with guardian's tacit or express general consent. Limitations. Applies only to specific acts where independent action is granted. Consent can be revoked at any time. Certain transactions require guardian's direct involvement, for example, immovable property transactions. Exceptions where minors may act independently. Accepting a donation, as it imposes no obligations. Depositing money in a bank, if the bank allows it. Medical treatment where legally permitted. Contracts by guardians on behalf of minors. Guardian can enter into contracts on behalf of a minor. Contracts requiring minors' cooperation. Some contracts, for example, engagement contracts, require both guardian and minor's consent. Contracts requiring additional approval. Transactions involving immovable property. If the value is above R250,000 High Court approval required. If below R250,000 Master of the High Court's approval required. Restitutio in integrum, restoration of original position. Minors can escape liability if the contract was prejudicial at the time of conclusion. Court may order restitutio in integrum, restoring both parties to pre-contract positions. Exceptions where minor is bound. Fraudulently misrepresented themselves as an adult. Ratified the contract after reaching majority. Prescription, time limit for claims. 3 years from date of claim, unless delayed by minority. Under Prescription Act, minor has 1 year after reaching majority to claim restitutio in integrum. Effect of contracts entered without required consent. Cannot be enforced against the minor, but is enforceable against the other party if the minor elects to perform. Guardian's assistance in performance equals implicit ratification. Unjustified enrichment, if the minor already received performance, they must return it. Delictual liability, other party may sue if the minor fraudulently misrepresented their majority status. Consumer Protection Act and minors. Contracts with unemancipated minors are voidable unless an adult responsible for the minor consented. The contract was ratified after the minor reached majority. Exceptions. The contract remains binding if the minor misled the supplier about their capacity. 5.3. Two married persons. Marriage out of community of property. Each spouse retains separate estates for contractual capacity, if antenuptial contract is verbal or written binding between spouses, notarially executed and registered binding on third parties. Marriage in community of property. Joint estate contractual capacity limited by law. Both spouses co-administer the estate. Some contracts require the consent of the other spouse. Informal consent, express or tacit. Written consent for specific transactions. Written consent attested by 2 witnesses for major transactions. Unauthorized contracts. If the third party was unaware of lack of consent, joint estate is bound. Loss may be recovered from the contracting spouse's share upon divorce or death. Separate estate in community of property. Example, property inherited with the stipulation that it remains separate. Spouse has full contractual capacity over separate property. _ 5.323 Insolvent persons. Insolvency alone does not limit contractual capacity. Sequestration, court-ordered insolvency. Estate vests in a trustee who administers it. Insolvent can contract but cannot dispose of estate assets. Requires trustees' written consent for contracts affecting the estate. Pre-sequestration contracts. Set aside if they unfairly benefited one creditor. Void if assets were transferred without value. _ 5.3.2.4 Prodigals. Definition: a person who squanders assets irresponsibly, endangering themselves or dependents. Declared prodigal by court. Contractual capacity similar to a minor. Estate managed by curator, whose consent is required for contracts imposing obligations. Contracts without consent. Voidable, not automatically void. Can be ratified by curator. Curatorship for other reasons. Persons unable to manage affairs due to disability or illness may also be placed under curatorship. _ These notes provide a concise yet comprehensive summary of contractual capacity, ensuring key legislative provisions and case law principles are included. Let me know if you need any modifications or further elaboration. Next page. Here are detailed study notes summarizing the provided text. _ 5.3. 2 persons with limited contractual capacity. 5.3.2.1 Minors. Definition: a minor is a person aged 7 to 18 years. General rule: a minor lacks full contractual capacity and requires guardians' consent to enter binding contracts. Consent can be given before, at the time of, or after contracting ratification. Indifference does not equal consent. If the guardian refuses consent, the court can intervene as the upper guardian of all minors. Emancipation: a minor may act independently in certain transactions if the guardian expressly or tacitly consents. Guardian's consent can be revoked, returning the minor to limited capacity. Certain laws prohibit emancipation, for example, where a statute requires parental/court consent. Contracts without guardian's assistance. Minors can accept rights-only contracts, for example, donations. Statutory exceptions. Minors 16+ years can open bank accounts, if the bank's constitution allows. Minors can independently contract for medical treatment. Guardian contracts on behalf of minor. The minor is bound even if unaware of the contract. Some contracts require the minor's cooperation, for example, engagement contracts. Official consent required. Certain transactions require court or master of high court consent, for example, alienating/encumbering property above R250,000, prejudicial contracts and restitutio in integrum. If the contract was prejudicial at the time of conclusion, the court may set it aside and restore the parties to their prior positions. Time limits. Before majority, application by minor/guardian. After majority, former minor applies. Restitutio denied if minor fraudulently misrepresented being of age. Minor ratified the contract after majority. Prescription applies, generally 3 years, delayed until 1 year after majority, per S13 of the Prescription Act. Effect of contract without guardian's assistance. Cannot be enforced against the minor, but can be enforced against the other party, if the minor wishes to perform, if the guardian assists the minor in claiming performance. This ratifies the contract. If performance is lost/damaged, the other party may claim. Unjustified enrichment. Delictual damages, if minor misled them into believing they had contractual capacity. Consumer Protection Act. Contracts with an unemancipated minor are voidable unless adult consented, ratified by an adult or the minor after majority. Right to void lost if the minor misrepresented their capacity. 5.3.2 Married persons. Spouses married out of community of property have separate estates and full contractual capacity. If an antenuptial contract is registered within 3 months, it binds third parties. Spouses married in community of property have a joint estate. Contractual capacity is limited by statute. Both spouses jointly administer their estate and can act independently, except for certain transactions requiring consent. The Matrimonial Property Act prescribes types of consent: informal, express or tacit; written and attested by 2 witnesses; ratification possible if consent was lacking. If a spouse acts without required consent and the third party did not know consent was needed, the joint estate is bound. Upon divorce/death, losses are recouped from the responsible spouse's share. A spouse with a separate estate, for example, inheritance with exclusion clause, has full contractual capacity over that estate. 5.3.2.3 Insolvent persons. Insolvency alone does not affect contractual capacity. Upon sequestration, an insolvent's estate vests in a trustee, limiting their capacity. Valid contracts. Insolvent can contract, but cannot dispose of estate assets. Requires trustees' written consent for contracts that may affect the estate. Pre-sequestration contracts that benefit one creditor over others or involve assets disposed of without value can be set aside. 5.3.2.4 Prodigals. A prodigal is a person who wastes assets irresponsibly to the detriment of dependents. A court can declare a person a prodigal, appointing a curator who must consent to contracts imposing obligations. Contracts without curator consent are voidable, may be ratified by the curator. Curatorship also applies to persons unable to manage affairs due to disability/illness. 5.3.3 Persons with full contractual capacity. General rule: all natural persons not falling within limited capacity categories have full capacity. Exceptions: statutes may impose restrictions. For example, convicted fraudsters cannot be company directors. 5.4 Juristic persons. Definition: an artificial legal entity with legal personality can acquire rights and obligations. Examples: companies, close corporations, statutory bodies, for example, SAG, universities, public school governing bodies, certain voluntary associations, for example, clubs with separate legal personality. Not juristic persons. Partnerships, joint ventures, divisions of corporations. Trusts, legal personality exists only for certain statutory purposes. Limitations: cannot marry, adopt, or act as a guardian. Powers limited by constitutive documents, for example, company memorandum, club constitution. Ultra vires doctrine: contracts outside its scope are generally void, except for companies under the Companies Act. Contracts by juristic persons. A juristic person acts through natural persons, for example, directors, officers. Only authorized representatives can legally bind the entity. 5.5 The state. The state and its organs can enter into contracts under common law prerogative. Liability under State Liability Act. If contract was in the ordinary course of administration, contract was authorized by the responsible minister. Special principles: the state cannot contract away its discretionary powers. State contracts must align with public law, may be held to higher standards in contract performance due to administrative justice. Tender and procurement laws restrict its freedom to contract. This structured summary captures all key legal principles, legislation, and case law references, ensuring a comprehensive yet concise set of study notes. Let me know if you need further refinement or expansion on any specific section. Next page. Here are detailed study notes summarizing the provided text. 6. Formalities. 6.1 Introduction. General rule: no formalities are required for a contract to be valid unless specified by law or agreed upon by the parties. Exceptions: 1. Statutory formalities. Certain contracts require formalities such as writing, notarial execution, or registration. 2. Contractual formalities. Parties may agree that their contract, or variations, cancellations, or waivers, will only be binding if certain formalities are met, for example, in writing and signed. Practical consideration: written contracts are advisable for proof of existence and terms. The onus of proving the contract's terms falls on the enforcing party. 6.2 Formalities prescribed by law. 6.2.1 Prescribed formalities required for validity. Some contracts must comply with formalities to be valid. 6.2.1.1 Alienation of land. Legal requirement. In terms of Section 2(1) of the Alienation of Land Act, a contract for the sale of land must be in writing, signed by both parties or their authorized agents. Effect of non-compliance: the contract is void and unenforceable. 6.2.1.2 Suretyship. Legal requirement. Under Section 6 of the General Law Amendment Act, a contract of suretyship must be in writing, signed by the surety or their authorized agent. Effect of non-compliance: the contract is void and unenforceable. 6.2.1.3 Donation. Legal requirement. Under Section 5 of the General Law Amendment Act, a gratuitous promise to donate must be in writing, signed by the donor or their authorized agent. Exceptions: executed donations, where performance has already taken place, do not require writing. Donations between spouses are valid without writing. 6.2.2 Prescribed formalities required for enforcement against third parties. Some contracts are valid between the parties but require formalities for enforcement against third parties. 6.2.2.1 Antenuptial contracts. Legal requirement: must be in writing, executed before a notary, registered within 3 months at the deeds office. Effect of non-compliance: the contract is valid between the spouses but cannot be enforced against third parties, for example, creditors. 6.2.2 Long leases of land. Legal requirement: a lease exceeding 10 years must be registered at the deeds office to bind third parties. Effect of non-compliance: the lease is valid between the parties but does not bind third parties, for example, new landowners. 6.2.3 Formalities in electronic contracts. The Electronic Communications and Transactions (ECT) Act allows for contracts to be concluded electronically. Exceptions: certain contracts cannot be concluded electronically, including alienation of land, wills. 6.2.4 Diverse other statutory instances. Various other statutes impose formalities for specific contracts, for example, credit agreements, employment contracts, consumer contracts. 6.3 Formalities stipulated by the parties. 6.3.1 Creation of the contract. Parties can stipulate their own formalities, for example, that a contract must be in writing and signed to be binding. If the contract is not reduced to writing, it may not be enforced. 6.3 to Variation of the contract, non-variation clauses and the Chiffren principle. Non-variation clause, a clause stating that any variation of the contract must be in writing and signed. Chiffren principle, SA Central Cupran Mascapi BPK v Chiffren. A contractual non-variation clause is enforceable. Any attempt to vary the contract orally or informally is invalid. 6.3.3 Cancellation of the contract, non-cancellation clauses. Non-cancellation clause requires that any cancellation must be in writing and signed. Effect: a contract cannot be cancelled orally if such a clause exists. Underscore. 6.3.4 Limiting the Chiffon Principle. The Chiffon Principle is subject to certain limitations. 6.3.4.1 Restrictive interpretation. Courts interpret non-variation clauses strictly, and only apply them to variations of contractual obligations. 6.3.4.2 Where enforcement would be against public policy. A non-variation clause may be unenforceable if it violates public policy, for example, if it causes undue hardship. 6.3.4.3 Where a party is stopped from enforcing a non-variation clause. Estoppel applies if one party led the other to believe that an informal variation was valid. The other party acted on this belief to their detriment. The enforcing party cannot then rely on the non-variation clause. Underscore. 6.3.5 Non-waiver clause. A non-waiver clause states that failure to enforce a contractual right does not amount to a waiver, prevents a party from losing rights due to inaction or delay. Underscore. Key takeaways. Contracts generally do not require formalities, except where statutes or the parties require them. Certain contracts, for example, land sales, suretyship, donations, must be in writing to be valid. Some contracts, for example, antenuptial contracts, long leases require formalities to be enforceable against third parties. Electronic contracts are valid, except for specific exclusions, for example, land sales, wills. The Chiffon Principle makes non-variation clauses strictly enforceable, but exceptions exist where public policy or estoppel applies. Non-waiver clauses prevent the loss of contractual rights due to inaction. Underscore. These notes provide a structured and detailed summary of contract formalities, covering legislation, case law, and key principles. Let me know if you need any refinements. Next. Page. Study Notes Formalities in Contract Law. 6.1 Introduction. General Rule: no formalities required for contract validity. Parties may express intentions in any form. Exceptions. 1. Statutory formalities: writing, notarial execution, registration required for certain contracts. 2. Agreed formalities: parties may require specific formalities, for example, writing, signing, for creation, variation or cancellation. Advantages of written contracts: facilitates proof of existence and terms, burden of proof on enforcing party. Underscore. 6.2 Formalities prescribed by law. Statutory requirements: some contracts must be in writing, signed, notarially executed, or registered. Electronic contracts: special formalities may apply. General principles: all material terms must be in writing. Implied terms, naturalia, and tacit terms need not be in writing. Terms may be in multiple documents. Variation of material terms must be in writing unless the variation is an extension of time, cancellation, or revival of a cancelled contract. Estoppel generally not available when a party misleads another into believing an oral variation is valid. Non-compliance consequences. Contract is void. Performance under a void contract may be recovered via enrichment actions. Carlos v. McCusker recognized a new enrichment action for defective land alienation, criticized and later rejected. Wilkin v. Kohler, no enrichment action if both parties performed fully. Legislative intervention, 1981, created a special enrichment action and validated transfers with full performance despite formal defects. Underscore. 6.2.1 Prescribed formalities required for validity. Certain contracts must be in writing and signed. Failure renders contract void. 6.2.1.1 Alienation of land. Section 2(1) of the Alienation of Land Act. Alienation, sale, exchange, donation, must be in a signed deed of alienation. Purpose: legal certainty, fraud prevention, reduced litigation. Applicability: essentialia of sale, exchange, or donation must be met. Signatory must have written authorization, except for corporate organs like managing directors. Exemptions. Auction sales, if not an installment sale. Right of preemption relating to land sale. Installment sales at auctions, conditions must be read in public, and buyer must receive a contract copy. 6.2.1.2 Suretyship. Defined agreement where a surety guarantees the debtor's performance to a creditor. Section 6 of the General Law Amendment Act. Suretyship must be in writing and signed by or on behalf of the surety. Creditor's signature is not required. Policy considerations. Legal certainty. Ensures surety understands obligations. Issues. Writing requirements may cause disputes rather than prevent them. Consumer protection statutes. For example, Housing Consumers Protection Measures Act, National Credit Act, aim to inform consumers but do not always succeed. Many sign contracts without reading them. These study notes summarize the key formalities required for contract validity, emphasizing legislative provisions, case law, and policy considerations. Next page. Study notes formalities prescribed by law. 6.2 Formalities prescribed by law. Some contracts require prescribed formalities: writing, signing, notarial execution, registration, for validity. Formalities serve different purposes, including preventing fraud and ensuring legal certainty. General principles for writing requirements. All material terms must be in writing. Implied, naturalia, and tacit terms need not be in writing. Terms can be in separate documents. Material variations must also be in writing. Oral variations may be misleading, but usually cannot be upheld due to estoppel limitations. Non-compliance renders the contract void, but enrichment actions may allow recovery of performance. Key case, Carlos v. McCusker. Developed a new enrichment action for void alienations of land. Later rejected by courts and commentators. Wilkin v. Kohler held no enrichment action if both parties performed fully. 1981 legislative intervention created a special enrichment action for land alienation. 6.2.1 Prescribed formalities required for validity. Certain contracts must be in writing and signed to be valid. Noncompliance results in nullity. 6.2.1.1 Alienation of land. Section 2(1) of the Alienation of Land Act. Any alienation, sale, exchange, donation, must be an assigned deed of alienation. Aims to ensure legal certainty and prevent fraud. Applicability of the Act depends on contract type, sale, exchange, donation, determined by essentialia. Signing requirements. Agents must have written authority. Companies sign through their organs, not agents. Exceptions. Sales by auction. Right of preemption. Special rules for installment sales at auctions. Conditions of sale must be read publicly before the auction. Purchaser must receive a contract copy immediately after the auction. 6.2.1.2 Suretyship. Section 6 of the General Law Amendment Act. Suretyships must be in a signed document. The creditor does not need to sign. Purpose. Ensures certainty. Informs the surety of obligations. 6.2.1.3 Donation. Section 5 of the General Law Amendment Act. Executory donations not yet completed must be in writing, signed by the donor. The donee must accept but need not sign. No witness required for the deed. Oral donations are valid if completed by delivery. 6.2.2 Prescribed formalities required for enforcement against third parties. Some contracts, though valid between the parties, require further formalities for third-party enforcement. 6.2.2.1 Antenuptial contracts. Oral contracts are valid between spouses. To bind third parties, the contract must be notarially executed and registered within 3 months. 6.2.2 Long leases of land. Section 1 of the Formalities in Respect of Leases of Land Act. Oral leases are valid. Leases over 10 years must be registered against the title deed for enforceability against creditors or successors. Doctrine of notice applies if third parties knew of the lease. _ 6.2.3 Formalities in electronic contracts. Section 12 of the Electronic Communications and Transactions Act. A writing requirement is met if the document exists in a data message and is accessible. Exclusions: alienation of land and long-term leases over 20 years. Inclusions: suretyships and executory donations excluding land. Applies to statutory and contractual formalities. Electronic signatures, Section 13(2). A standard electronic signature may suffice. Where a law requires a signature without specifying the type, an advanced electronic signature is required. Must be accredited by the Director General of the Department of Communications. _ 6.2.4 Other statutory formalities. Some statutes prescribe formalities without invalidating non-compliant contracts. Examples: 1. Housing Consumers Protection Measures Act. Contracts must be written, signed, and include annexures. Non-compliance does not void the contract. Builders cannot demand deposits if formalities are not met. Further violations may prevent payment from consumers. 2. National Credit Act. Credit agreements must be in a printable format. Courts decide whether non-compliance renders contracts unlawful. Variations must comply with prescribed formalities. 3. Consumer Protection Act. Does not require writing as a general validity requirement. _ 6.3 Formalities stipulated by the parties. Parties may impose their own formalities for creation, variation, or cancellation of a contract. 6.3.1 Creation of the contract. Written reduction of an oral agreement. 1. If writing is only for proof, the contract is valid even if unwritten. 2. If writing is a validity requirement, the contract is not binding until signed. Burden of proof. The party alleging that writing was a requirement must prove it. Key case: Goldblatt v. Fremantle. Court found no contract because the parties intended writing to be a requirement. De Bruin v. Brink. An oral agreement followed by a written embodiment does not necessarily mean writing was a validity requirement. Electronic contracts. If the parties require writing, compliance with Section 12 of the Electronic Communications and Transactions Act suffices. Modification of writing requirement. If the parties initially required writing, they can later waive this requirement, making an oral contract valid. _ Key cases. Carlos v. McCusker introduced an enrichment action for formally defective land alienations. Wilkin v. Kohler, no enrichment action available when both parties performed. Goldblatt v. Fremantle, if parties intended writing as a requirement, no contract exists until signed. De Bruin v. Brink, writing is not necessarily a validity requirement if terms were agreed upon orally. _ Key legislation. 1. Alienation of Land Act, Section 2(1) requires written, signed contracts for land alienation. 2. General Law Amendment Act, Sections 5 and 6, requires writing for suretyships and executory donations. 3. Formalities in respect of Leases of Land Act, Section 1, long leases must be registered to bind third parties. 4. Electronic Communications and Transactions Act, Sections 12 and 13, allows electronic writing and signatures. 5. Housing Consumers Protection Measures Act, writing formalities but does not invalidate contracts. 6. National Credit Act, requires certain forms, but does not automatically void non-compliant agreements. 7. Consumer Protection Act, generally does not require written contracts. _ This structured summary retains legislative references and case law while focusing on key points, ensuring a detailed yet concise study resource. Let me know if you need any refinements. Next. Page Summary of formalities in contract law. 6.2.1.3 Donation. Section 5 of the General Law Amendment Act. Executory donation contracts, not yet fulfilled, must be in writing and signed by the donor or their authorized agent before 2 witnesses. The deed of donation itself does not need to be witnessed. The donee must accept but need not sign the contract. Oral donations completed by delivery are binding. 6.2.2 Formalities for enforcement against third parties. Some contracts are valid between parties but require formalities for enforceability against third parties. 6.2.2.1 Antenuptial contracts. Oral antenuptial contracts are valid between parties, but must be notarially executed and registered within 3 months for enforceability against third parties. 6.2.2 Long leases of land. Oral leases are valid. Long-term leases, over 10 years, must be registered against the title deed to be enforceable against third parties. Doctrine of notice: third parties aware of an unregistered lease are bound. 6.2.3 Formalities in electronic contracts. Section 12 of the Electronic Communications and Transactions Act. A document in electronic form, data message, satisfies writing requirements. Excludes alienations of land and leases over 20 years. Applies to suretyships and executory donations except land. Section 13(2). Electronic signatures are equivalent to wet signatures if an advanced electronic signature is used. Advanced electronic signatures must be accredited by the Director General of Communications. 6.2.4 Other statutory formalities. Housing Consumers Protection Measures Act. Construction contracts must be in writing and signed. Non-compliance does not invalidate the contract but prevents home builders from collecting deposits or payments. National Credit Act. Credit agreements must be in writing, paper or printable electronic. Non-compliance does not void the agreement but allows courts to determine validity. Consumer Protection Act. No general writing requirement for consumer contracts. 6.3 Formalities stipulated by the parties. Parties can impose formalities for contract creation, variation, or cancellation. No party may unilaterally waive these formalities. 6.3.1 Creation of the contract. If parties agree to reduce an oral contract to writing. 1. For proof only, the contract is binding even if never written. 2. As a validity requirement, the contract only exists when written and signed. Presumption: writing is for proof, unless proven otherwise. Case law. Goldblatt v. Fremantle, no contract as parties intended writing for validity. De Bruin v. Brink, writing for record only does not affect validity. Electronic contracts fulfilling Section 12 of ECTA satisfy writing requirements. 6.3.2 Variation of the contract, non-variation clauses and Chiffren principle. Non-variation clauses: contracts cannot be changed except in writing and signed. Chiffren principle: SA Central Cooperatiu Brânmascapi BPK v. Chiffren. A non-variation clause is valid and binding. Enforces pacta sunt servanda: agreements must be upheld. Prevents disputes by ensuring certainty. Challenges to Chiffren principle. Courts have tried waiver, estoppel, pactum de non petendo, and good faith doctrines to mitigate unfair results. Risley v. Drotsky reaffirmed Chiffren, emphasizing legal certainty. 6.3.3 Cancellation of the contract, non-cancellation clauses. Contracts can be cancelled at any time by agreement unless a non-cancellation clause exists. Impala Distributors v. Taunus Chemical Manufacturing Company, Proprietary, Limited. A non-cancellation clause must be coupled with a non-variation clause to be effective. Unilateral cancellation due to breach is not affected. Obiter dicta: a non-variation clause alone may prevent oral cancellation, but this is debated. Next page. Limiting the Chiffren principle. 6.3.4.1 Restrictive interpretation. Non-variation clauses should be restrictively interpreted as they limit contractual freedom. Whether such a clause protects itself from oral variations depends on interpretation. A non-variation clause applies only to formal variations of a contract, but does not affect cancellations unilateral or by agreement, as they extinguish rather than vary the contract. Certain forms of waiver, which do not constitute contract variations. Forms of waiver not considered variations. Waiver of an accrued right, for example, right to cancel or claim damages. Discharge of an accrued obligation through substituted performance, datio insolutum. Release from obligation by the creditor. Agreement not to enforce a right for a limited time, pactum de non petendo. Application in the lease example. The oral agreement reducing rent is a variation making it unenforceable. The lessee still owes R3,500 per month. Lessor's acceptance of R3,000 each month is waiver. Waives the right to cancel for non-payment. Waives right to claim the R500 shortfall. In the 5th month, the lessor did not accept R3,000, meaning he can claim R3,500. If the lessor cancels without warning after accepting reduced rent for months, it may be unconscionable. Possible pactum de non petendo argument. The lessor's conduct may imply an agreement not to enforce cancellation without warning. 6.3.4. 2. Where enforcement would be against public policy. Courts refuse to enforce a non-variation clause if it contradicts public policy. Scenarios where enforcement may be against public policy. Fraudulent reliance on the clause. Bad faith enforcement is not enough unless it violates public interest. Unfair enforcement. Brisley v. Drotsky. Good faith is not a standalone principle but informs contract law. Baedeker case. Courts may refuse to enforce unfair clauses if it is so unreasonable as to be against public policy. Public policy considerations must align with constitutional values, for example, Ubuntu. Case law examples. Nyandeni Local Municipality v. Hlezo. Municipal manager used the non-variation clause to delay dismissal despite valid charges. The court found this to be an abuse of process and ruled enforcement against public policy. GF v. SH. The High Court refused to enforce a non-variation clause in a divorce settlement as it would not be in the best interests of the children, a constitutional value. Steyn v. Kari Kloof Malkari, Proprietary Limited. Public policy considerations outweighed the enforcement of the clause. SH v. GF, SCA ruling. Criticized the High Court's reasoning. Reinforced the Schifrin principle unless a constitutional value is at stake. Left uncertainty about whether fairness and reasonableness can override enforcement. 6.3.4.3 Estoppel as a defense. Courts recognize estoppel as a possible defense but no case has succeeded so far. Challenges to raising estoppel. Estoppel requires a reasonable reliance on a misrepresentation. It is usually unreasonable to believe an oral variation is binding if there is a non-variation clause. Conflicting views on estoppel. 1. Narrow approach estoppel only applies when it does not result in an informal variation of the contract. 2. Broad approach estoppel should apply even if it effectively negates the non-variation clause. Alternative to estoppel. Unnecessary to rely on estoppel if the obligation was discharged, release or datio insolutum. A pactum de non petendo was formed based on reasonable reliance. In such cases, the contract remains unchanged, and enforcement of the non-variation clause may be limited. Next. Page 6.3.4 Limiting the Schifrin principle. Courts seek to limit the Schifrin principle due to potentially unfair consequences. 6.3.4.1 Restrictive interpretation. Non-variation clauses restrict contractual freedom and must be interpreted narrowly. A non-variation clause applies only to contractual variations, not to cancellation or certain forms of waiver. Types of waiver that are not variations. Waiver of an accrued right, for example, right to cancel or claim damages. Datio insolutum, acceptance of substitute performance. Pactum de non petendo, agreement not to enforce a right temporarily. Application to case example. Oral variation of rent unenforceable due to non-variation clause. Lessor waived right to cancel by accepting reduced rent. Lessor cannot claim arrears for prior months but may claim full rent in the fifth month. Lessor's conduct may imply a pactum de non petendo, requiring warning before cancellation. 6.3.4 To enforcement against public policy. A non-variation clause will not be enforced if it contradicts public policy. Key cases. Risley v. Drotsky, bad faith alone does not make enforcement contrary to public policy. Bideka, fairness may influence public policy considerations. Nyandeni Local Municipality v. Hazel, enforcement was abusive and unconstitutional. GF v. SH, clause not enforced due to best interests of children. Stein v. Kari Kloof Malkari, enforcement was against public policy. SH v. GF, SCA, reaffirmed Schifrin, limiting High Court expansions. 6.3.4.3 Estoppel as a defense. Courts recognize estoppel as a possible defense but no reported case has succeeded. Estoppel requirements. A reasonable belief that a variation is binding. Misrepresentation by one party. Two views on estoppel. Limited scope. Estoppel only applies where it does not create an informal variation. Broader scope. Estoppel applies if it does not violate the non-variation clause's purpose. Reliance on estoppel may be unnecessary when the obligation is discharged by waiver, datio insolutum, or pactum de non petendo. 6.3.5 Non-waiver clause. Standard contractual clause preventing waiver through indulgence. Strictly interpreted and may preclude estoppel depending on wording. Table 6.1 Formalities for variation, cancellation, and waiver. Clause type valid if strict interpretation exclusions. Non-variation clause if it entrenches itself white tick mark emoji, excludes cancellation and some waivers. Non-cancellation clause if coupled with a non-variation clause white tick mark emoji, excludes waiver. Non-waiver clause if coupled with a non-variation clause white tick mark emoji, excludes cancellation. Figure 6.2, Mind map of Chapter 6. Reference to mind map included as Figure 6.2. Next page. Chapter 7 Legality. 7.1 Introduction. Sanctity of contract, pacta sunt servanda, agreements seriously entered into should be enforced. Public policy can override this principle when agreements conflict with societal interests. Sources of public policy considerations. Legislation. Common law. Good morals. Public interest. Illegality in contracts. Illegal contracts are unenforceable in law. Legality is a requirement for a valid contract. Impact of the Constitution. Since 1994, public policy is based on constitutional values. Balancing Act. Courts weigh public interest against private interests when determining enforceability. Two consequences of illegality. Void contracts, completely unenforceable. Valid but unenforceable contracts, recognized but not enforced. Scope of discussion, covers prominent examples but not an exhaustive list. _ 7.2 Illegal contracts that are void. Contracts are void if they violate common law or statutory law, have an unlawful conclusion, performance, or object. 7.2 On public interest. Public interest and public policy are often interchangeable. Contracts conflicting with public interest or statutory prohibitions are illegal and void. 7.2 The conclusion, performance, and object must be lawful. Contracts are void if their formation violates the law, performance is unlawful, purpose is against public policy. 7.3 Specific examples of illegal or invalid contracts. 7.3.1 Contracts against good morals. Void due to immorality, for example, agreements promoting crime or immorality. 7.3.2 Statutory illegality. Contracts prohibited by legislation, for example, agreements violating licensing laws. 7.3 7.2.3.3 Constitutional invalidity. Private and public contracts must align with constitutional values. 7.2.3.1 Private agreements. Private contracts violating constitutional rights are void. Case law, courts may declare contracts unconstitutional. 7.2.3.3.2 Public agreements. Government contracts must comply with constitutional requirements. 7.2.3.4 Pacta de quotalitas, champity, and maintenance. Pacta de quotalitas, lawyers' contingency fee agreements may be void if unethical. Champity and maintenance, agreements financing lawsuits may be invalid. 7.2.3.5 Unfair contracts. Contracts that are excessively unfair may be void due to public policy. 7.2.3.6 Unfair enforcement of a contract. Even if a contract is lawful, its enforcement may be unconscionable. 7.2.4 Consequences of a contract that is void for illegality. 7.2.4.1 Contract cannot be enforced. Ex turpi rule, ex turpi causa non oritur actio, no action can arise from an illegal contract. 7.2.2 Severing the illegal part of a contract. If part of a contract is illegal, courts may sever the unlawful terms and enforce the remainder. 7.2.4.3 Reclaiming performance under an illegal contract. Par delictum rule. Par delictum rule. Parties to an illegal contract cannot recover performance unless exceptions apply. 7.3 Illegal contracts that are valid but unenforceable. Some contracts are legal but cannot be enforced in court. 7.3.1 Wagering and gambling contracts. 7.3.1.1 The common law. Gambling contracts were historically void, but now depend on statutory regulation. 7.3.1.2 The National Gambling Act 7 of 2004. Certain gambling contracts are valid, but enforcement is subject to regulatory conditions. 7.3 To Agreements in restraint of trade. Restrictive covenants, for example, employment non-compete clauses, may be valid but unenforceable if unreasonable. This summary provides a detailed and structured breakdown of Chapter 7, focusing on key legal principles, statutory references, and case law applications while maintaining depth and clarity. Next page. Here's a detailed summary of Chapter 7 on legality from Thomas Floyd and Chris Pretorius. Illegal contracts. 7.2 Illegal contracts that are void. Contracts may be void due to illegality if they are against public interest, recognized at common law or in statute, or contravene moral and constitutional values. The consequences of such illegality are examined below. 7.2 On public interest. Contracts are illegal if contrary to good morals, contra bonos mores, or public policy, often overlapping principles. Sasfin, proprietary, limited v. Books, agreements harmful to the community, whether against law, morality, or economic expedience, will not be enforced. The interests of society take precedence over individual interests. Recognized public interests. Sanctity of contracts. Voluntarily concluded contracts should be enforced. Simple justice between individuals. Equal bargaining power in contracts. Proper administration of justice. Preservation of state security. Proper functioning of public service. Protection of legal rights. Public policy is flexible and changes over time, but courts intervene sparingly and only in clear cases of public harm. Courts consider the tendency of a contract, not necessarily its proven results, to determine illegality. Courts avoid declaring a contract contrary to public policy based on personal opinions of fairness. Since 1994, public policy is primarily informed by the Constitution and the Bill of Rights, though not exclusively. Precedents guide legality, but case law pre-1994 must be tested against constitutional values. Approach to contractual terms conflicting with the Constitution. Barkhazen v. Napier, the Constitutional Court questioned whether a contractual term could be tested directly against the Bill of Rights. 2 obstacles. Contractual terms are neither laws of general application nor conduct. Instead, courts assess whether the term is contrary to public policy. Courts balance pacta sunt servanda, sanctity of contract, with constitutional values. Abve Pridewin Preparatory School allow direct application of the Bill of Rights where constitutional issues are directly at stake. Courts weigh competing public interests, but traditionally sanctity of contract prevails. Freedom of contract, dignity, and autonomy are key constitutional values, but bargaining inequality can diminish contractual freedom. Barkhuizen reaffirmed that enforcement of a contract must be fair and reasonable. Public policy allows enforcement of contracts but prevents unjust or unreasonable contractual terms. Onus of proving illegality rests on the party raising it, but courts can raise it ex officio if evident from the contract or clear evidence. 7. 2 Lawful conclusion, performance, and object of contracts. A contract must be lawful in its conclusion, performance, and object. Examples of void contracts: statutorily prohibited contracts, certain pacta accessoria, contracts with enemy subjects, agreements ousting court jurisdiction, for example, summary execution clauses, conclusive proof clauses. If a conclusive proof clause makes a creditor the judge in their own cause, it is void. If an independent third party issues it, it may be valid. Illegal performance, contracts for crimes, murder, robbery, or delicts are void. If a contract can be performed lawfully or unlawfully, it is presumed lawful unless proven otherwise. Illegal purpose, a contract is void only if both parties share an illegal intent. An innocent party unaware of the other's illegal intent may refuse performance. Case law. Kennedy v. Steenkamp, a contract to buy and cut diamonds illegally was void, as the promissory note used to finance it was also illegal. Contracts preferring one creditor over others in insolvency are void. I've summarized the key points of illegal contracts that are void, highlighting relevant case law and statutory principles. Let me know if you need further refinements or additional details. Next. Page 7 to 3 specific examples of illegal or invalid contracts. Various types of illegal contracts exist, with illegality arising from different sources. 7.2.3.1 Contracts against good morals, contra bonos mores. Courts sometimes use good morals and public policy interchangeably in illegality cases. Definition: good morals refer to acceptable behavior within the community. Examples of void contracts: agreements for immoral or sexually reprehensible conduct, payment to a prostitute for sexual services, insurance coverage for a brothel, contracts that compromise child custody in exchange for money. Maseko v. Maseko. Plaintiff married the defendant to transfer her house into his name, avoid attachment by creditors, and later divorce him. Court held the contract void on 3 grounds. 1. Immoral and deceptive, designed to mislead creditors. 2. Undermined marriage as an institution. 3. Committed fraud against the court in divorce proceedings. 7.2.3.2 Statutory illegality. Statutory provisions determine whether a contract is void. If a statute explicitly declares a contract void, it is automatically unenforceable. Examples: contracts concerning dangerous weapons, firearms, alcohol, drugs, uncut diamonds. Contracts designed to circumvent legal prohibitions, in fraudum legis, are also void. Key legislative provisions. National Credit Act, NCA, Section 90. Declares certain clauses in credit agreements unlawful. Remedies available: severance of unlawful provision, modification of the agreement to make it lawful, complete nullification of the contract. Consumer Protection Act, CPA, Section 51. Prohibits specific unfair contract terms, declaring them void. Determining implicit nullity in legislation, courts assess various factors. 1. Objective of the statute. If enforcing the contract results in harm the law seeks to prevent, it suggests the contract is void. 2. Criminal sanctions. If the law imposes criminal penalties, it usually indicates legislative intent to void the contract. 3. Revenue collection. If the statute exists to protect state revenue, the contract may still be valid. 4. Public versus private interest. If the law protects the public, the contract is more likely to be void. 5. Practical consequences. Courts weigh whether voiding the contract causes more harm than allowing it to stand. Example: National Gambling Act and wagering contracts. National Gambling Act regulates gambling and wagering contracts. Key provisions. Section 8. Prohibits gambling unless licensed, specifically permitted by law. An informal bet between private individuals with no bookmaker or monetary gain beyond winnings. Informal bets that do not meet statutory conditions are illegal. Criminal offenses. Engaging in unlawful gambling is a crime. Knowingly paying out winnings from illegal gambling is also criminal. Section 16(1). Debts from unlawful gambling activities are unenforceable. Common law generally recognizes wagering contracts as valid but unenforceable. Unlawful winnings are forfeitable to the state. Legislative intent analysis. The Act regulates, licenses, and controls gambling for public protection. Section 8's prohibition serves the public interest, not merely state revenue. Making unlawful wagering contracts merely unenforceable would undermine the law's purpose. Legislative measures against paying winnings and forfeiting winnings further indicate intent for such contracts to be void. Thus, the National Gambling Act implies that unlawful wagering contracts are void, not just unenforceable. Next. Page 7-3 specific examples of illegal or invalid contracts. Different types of illegal contracts arise from various sources. 7-3.1 Contracts against good morals. Distinction between contracts contrary to good morals, contra bonos mores, and those against public policy is unclear. Courts sometimes treat these concepts interchangeably. Good morals refer to acceptable behavior in the community. Examples of contracts against good morals. Sexually immoral agreements. Contracts to pay a prostitute for sexual intercourse or insure a brothel are void. Custody in exchange for financial reward. A contract where a divorced father trades custody of his children for financial benefit is void. Fraudulent marriage contracts. Maseko v. Maseko. Plaintiff agreed to marry, transfer a house to the spouse's name, and divorce after avoiding creditor attachment. Court found the contract illegal on 3 grounds. 1. Fraudulent misrepresentation, designed to mislead creditors. 2. Undermining marriage, violated the institution of marriage. 3. Court fraud, perpetrated fraud in divorce proceedings. Court noted that fraudulent contracts may violate both good morals and public policy. 7.2.3. Statutory illegality. Some contracts are illegal because they are expressly or impliedly prohibited by legislation. A contract is void if the statute explicitly declares it to be of no force or effect. Examples of statutory illegality. Contracts involving the sale of dangerous weapons, firearms, alcohol, drugs, and uncut diamonds. Contracts aimed at circumventing statutory prohibitions, in fraudem legis, are void. Key legislation. Section 90, National Credit Act. Declares certain credit agreement clauses unlawful. Remedies. Sever unlawful provisions. Alter the agreement to comply with the law. Declare the entire agreement void. Section 51, Consumer Protection Act. Prohibits specific consumer contract clauses. Declares such clauses void. Implied statutory nullity, court considerations. 1. Objective of the statute. If enforcing a contract results in harm the law aims to prevent, it suggests nullity. 2. Criminal sanctions. If violating the law is a crime, the contract is likely void unless criminal punishment sufficiently prevents harm. 3. Revenue protection. If a law primarily protects state revenue, contracts may still be valid. 4. Public interest. If a law protects the public rather than individuals, contracts violating it are likely void. 5. Balance of convenience. If voiding a contract causes more harm than allowing it to stand, courts may avoid nullity. Example: illegal gambling contracts. National Gambling Act, Section 8 prohibits gambling unless licensed gambling is involved. It is social gambling permitted by provincial law. It is a legitimate informal bet. Informal bets must meet these conditions. No party is a bookmaker or professional gambler. No party earns money beyond winning the bet itself. Prohibited informal bets. Bets where parties intend to create enforceable contractual relationships. Contravention is a crime. Section 16(1) declares debts from unlawful gambling activities unenforceable. However, common law wagering contracts remain valid but unenforceable. State forfeiture mechanism. Winnings from illegal gambling activities may be forfeited to the state. Legislator's intention. Since winnings from unlawful gambling cannot be paid out, and must be forfeited, the underlying contract is void. 7.3.3 Constitutional invalidity. A contract may be invalid due to direct or indirect application of constitutional rights. 7.3.1 Private agreements. Direct horizontal application. A constitutional right is directly applied between private parties. At v. Pridewin Preparatory School, court found that a private school's contract termination violated the constitutional rights of children. Indirect horizontal application. The Bill of Rights influences common law principles like public policy. Barkhazen v. Napier focuses on whether a contractual term or enforcement violates public policy. Key case: Ab v. Pridewin Preparatory School. Independent school terminated a contract with parents due to their misconduct. Parents challenged this on public policy and constitutional grounds. High Court and Supreme Court of Appeal ruled in favor of the school. Constitutional Court, majority decision by Theron J. found the direct application of the Bill of Rights appropriate. Focused on the best interests of the child, S28-2, and right to basic education, S29-1A. The school should have allowed parents to make representations before termination. Decision was unconstitutional and invalid. Significance. The ruling confirms direct horizontal application of constitutional rights in private contracts. 7.2.3.3.2 Public agreements. Public agreements involve the state, meaning the Constitution applies directly. Section 8(1) of the Constitution, the Bill of Rights applies to disputes between the state and private parties. Key case: Malan v. City of Cape Town. Issue: a municipality terminated a public rental housing lease without cause. Court's ruling. The right to housing, S26, prevents arbitrary lease termination. Government agencies must have good cause before cancelling a lease. State procurement and Section 217. Section 217. State contracts must be fair, equitable, transparent, competitive, and cost-effective. Protects against fraud and corruption. Key cases: All Pay Consolidated Investment Holdings v. CEO of Social Security Agency. Court emphasized that remedies must consider public interest when setting aside procurement contracts. Buffalo City Metropolitan Municipality v. Asla Construction. A procurement contract was declared invalid, but the court did not set it aside to protect accrued rights. Section 172, Powers of Courts in Constitutional Matters. Courts have wide discretion in constitutional disputes. Invalid procurement processes lead to contract nullity, as seen in Section 217 violations. Conclusion. Contracts are illegal or invalid if they violate good morals, contra bonos mores, statutory provisions, constitutional principles, direct or indirect application. Courts apply a contextual approach to determine nullity, considering legislative intent, constitutional values, and public interest. Next. Page 7. 7.2.3.3 Constitutional invalidity. 7.2.3.1 Private agreements. A constitutional provision may apply directly or indirectly to a private contractual dispute. Direct application. A constitutional right is infringed within a contractual context. Indirect application. A contractual term or enforcement is tested against public policy, influenced by constitutional values. Bachelor v. Napier. Indirect horizontal application is the preferred method for constitutional challenges to contracts. Abb v. Pridewin Preparatory School. Private school terminated a contract with parents based on a termination clause. Parents challenged the cancellation on both public policy and constitutional grounds. High Court and Supreme Court of Appeal, SCA, found no constitutional duty on the school to provide education. Constitutional Court focused on the constitutional rights of the children rather than public policy, held that Section 8(2) of the Constitution imposes obligations on private entities. The school failed to consider the children's best interests and their right to education before termination. Ruling, the contract termination was unconstitutional and invalid. The Pridewin case demonstrates that direct horizontal application of the Bill of Rights can invalidate a private agreement if constitutional rights are at stake. 7.2.3.3.2 Public agreements. The Bill of Rights applies directly to public contracts due to Section 8(1). Malan v. City of Cape Town. A city council cannot terminate a lease for public housing without good cause, even if contractually permitted. The court emphasized the constitutional right to housing over contractual discretion. Section 217 requires state procurement processes to be fair, equitable, transparent, competitive, and cost-effective. Buffalo City Metropolitan Municipality v. Usla Construction. Court found a procurement contract invalid, but preserved accrued rights under Section 172 of the Constitution. If a tender process violates Section 217, the contract itself becomes invalid. 7.2.3.4 Pacta de Quota-Litis, Champity, and Maintenance. Pactum de Quota-Litis. Agreement where litigation is funded in exchange for a share of the proceeds. Historically prohibited in Roman, Dutch and English law due to concerns over speculative litigation. English law distinction. Champitus agreements, funding litigation in exchange for a portion of the proceeds. Maintenance agreements, improper assistance in litigation without legitimate interest. South African law. Common law rule, agreements where outsiders finance litigation for a share of proceeds are generally invalid, unless concluded in good faith to assist a litigant. Contingency Fees Act allows legal practitioners to enter into contingency fee agreements. No-win, no-fee agreements. Agreements permitting a higher than usual fee if successful. All other contingency fee agreements remain illegal. PricewaterhouseCoopers Incorporated v. National Potato Cooperative Limited. Supreme Court of Appeal ruled that Pacta de Quota-Litis are no longer per se against public policy, recognized the constitutional right to access courts, Section 34, and freedom of contract. 7.2.3.5 Unfair contracts. Contracts contrary to public policy can be declared unenforceable if they are exceptionally unfair, are contrary to constitutional values, for example, Ubuntu, violate the public interest, Barkhazen v. Napier, recognize fairness, justice, and equity as part of public policy, unclear if unfairness alone is enough to invalidate a contract, good faith, an underlying value in contract law, but not an independent rule. Courts consider whether a party unreasonably prioritizes self-interest at the expense of another. Sasfin, Proprietary, Limited v. Books. A contract that reduced a doctor to a virtual slave for a financier was found against public policy. Courts should only strike down contracts in clear cases. Standard Bank of SA Limited v. Wilkinson. Public policy is judged against commercial realities and community interests. Contracts should only be voided if inimical to public interests. Afrox Healthcare BPK v. Stridham. Courts recognize unequal bargaining power as a factor in evaluating public policy. Barkhazen, time limitation clause. Short time limits on claims may be unconstitutional if they effectively deny access to courts. The test for validity includes whether the time limit is unreasonable, whether there was unequal bargaining power. Held, the clause was valid as it did not completely prevent legal recourse. African Dawn Property Finance 2, Proprietary, Limited v. Dreams Travel and Tours CC. Fairness alone does not determine public policy, there must be an additional public interest consideration. Next. Page 7.2.3.4 Pacta de Quotalitas, Champity, and Maintenance. Pactum de Quotalitas, agreement where a party funds litigation in exchange for a share of the proceeds if successful. Roman and Roman Dutch law viewed such agreements as an abuse of the legal process and speculative litigation. English law influence distinguishes between champitus and maintenance agreements. Champity, similar to Pacta de Quotalitas, where a third party funds litigation for a share of proceeds. Maintenance, improper assistance in litigation, without a legitimate interest or just cause. South African courts declared such agreements invalid unless concluded in good faith to assist a litigant in exercising rights. Contingency Fees Act allows attorneys/advocates to enter contingency fee agreements if the case has reasonable prospects. Permits no win, no fee and agreements where fees exceed usual rates if the case is won. Other contingency fee agreements remain illegal. PricewaterhouseCoopers Incorporated v. National Potato Cooperative Limited. Supreme Court of Appeal, SCA, ruled Pacta de Quotalitas is no longer against public policy or void. Recognized that the civil justice system is well developed and independent. Contingency Fees Act reflects changing public policy by permitting speculative litigation. Found that enabling access to courts aligns with constitutional rights and freedom of contract. _ 7.2.3.5 Unfair contracts. Public policy considerations. Requires simple justice between parties. Addresses inequality of bargaining power. Influenced by fairness, justice, equity, and Ubuntu. Barkhazen v. Napier. Role of fairness in public policy. Courts debated whether unfairness alone invalidates a contract or if it must also harm the public interest. Good faith is an underlying principle but not a self-standing rule in contract law. Sasfin, Proprietary, Limited v. Books. Contracts against public policy if detrimental to community interests. Courts must exercise caution in invalidating contracts to prevent uncertainty. In this case, the contract placed one party in a position of economic servitude, making it unconscionable. Standard Bank of SA Limited v. Wilkinson. Commercial life context considered in assessing public policy. Courts must only intervene when contracts are clearly harmful to community interests. Afrox Healthcare BPK v. Stridham. Unequal bargaining power is a factor in public policy considerations. Barkhazen v. Napier. Examined a time limitation clause in an insurance contract. The right to seek legal redress, S.34 Constitution, is a public interest. A clause that effectively denies access to courts would be invalid. Fairness alone does not make a contract void, there must be a public interest concern. African Dawn Property Finance 2, Proprietary, Limited v. Dreams Travel and Tours CC. Unfairness alone does not violate constitutional principles. Clarification in Bidecka 231 CCV Trustees for the time being of the Oregon Trust. Addressed uncertainty in case law on unfairness and public policy. Key principles reaffirmed. Pacta sunt servanda remains important, but public policy includes broader constitutional rights and values. Contracts contrary to constitutional values or public policy may be declared invalid. Courts can refuse enforcement where a contract's application in specific circumstances would be against public policy. Onus on the party challenging the contract. Courts must use this power sparingly, but must not shield unfair contracts behind formalism. Public harm need not be substantial and incontestable for a contract to be declared void. Abstract fairness and reasonableness alone cannot invalidate a contract. Biediker reconciled differing approaches of the SCA and Constitutional Court, ensuring greater legal certainty. Bota v. Rich no contextualized. Did not establish disproportionality or unfairness as self-standing grounds for invalidating contracts. Varkhazen remains the leading authority on the role of fairness in contract law. Limiting contractual freedom in unequal bargaining situations. Courts do not have a general discretion to invalidate unfair contracts for the sake of fairness. Freedom of contract. Parties must take responsibility for their choices, including bad bargains. Law protects weaker parties in specific instances. Rules on improperly obtained consensus, for example, misrepresentation, duress. Public policy considerations, for example, inequality of bargaining power. Legislation. National Credit Act protects consumers from unfair credit agreements. Consumer Protection Act regulates unfair terms and abusive contractual practices. Unconscionability doctrine, proposed by commentators. A contract is unconscionable if one party abuses its dominant position to impose onerous terms. Would align common law with Consumer Protection Act but risks overlapping with existing contract rules. Alternative approach, further develop improperly obtained consensus principles rather than introduce a new doctrine. Illegality doctrine allows specific clauses to be invalidated without voiding entire contracts. Next. Page 7.2.3.6 Equitable jurisdiction under the Consumer Protection Act, CPA. Consumer Protection Act, CPA, grants courts equitable jurisdiction within its scope of application. Section 48(1)(a) prohibits suppliers from offering goods/services at unreasonable prices or on unfair, unjust, or unreasonable terms. Section 48(2) identifies specific prohibited contractual terms including contracts that are excessively one-sided in favor of the supplier, contracts so adverse to the consumer that they become inequitable, unfair, unreasonable, unjust, or unconscionable terms, failure to draw consumers' attention to important terms, their nature or effect. 7.2.3.7 Factors for determining unconscionability or unfairness. Courts may assess whether a contract is unconscionable, unjust, unreasonable, or unfair by considering circumstances at the time of contract formation or reasonably foreseeable factors, conduct of the parties leading to the contract, whether the consumer was required to do something unnecessary for the supplier's legitimate interests, fair value of the goods/services, alternative options available to the consumer for similar goods/services, manufacturing conditions of the goods, nature of the parties and their relationship, including relative capacity, education, experience, sophistication, and bargaining power, existence and extent of negotiations between the parties, clarity and accessibility of contract terms, compliance with the requirement that information must be in plain and understandable language, consumers' awareness of unfair terms, considering industry customs, trade practices, and past dealings between the parties. 7.2.3.8 Remedies for unconscionable, unjust, or unfair contracts. If a court declares a contract or term unfair, it may order restitution of money or goods to the consumer, compensation for consumers' losses or expenses related to the contract or court proceedings. This legal framework limits absolute contractual freedom by ensuring consumer protection in cases of unfair bargaining power, hidden terms, or excessive contractual disadvantage. Next. Page 7.2.3.6 Unfair enforcement of a contract. General principle. Courts recognize that unfair enforcement of a contract may be contrary to public policy. Brisley v. Drotsky, the Supreme Court of Appeal, SCA, assumed that the Sasvin principle, unconscionability rendering contracts unenforceable, could apply to enforcement of contractual terms. In this case, an oral agreement contradicted a non-variation clause in a lease. The lessor accepted late payments for 5 months but later cancelled the lease. The court ruled that no exceptional unfairness occurred because The non-variation clause exists to prevent disputes over later oral agreements. Accepting late payments did not worsen the lessee's position, as cancellation could have happened earlier. No specific public interest was infringed. Barkhazen v. Napier, Unfair Enforcement and Public Policy. The Constitutional Court ruled that a contract clause may be unenforceable if its application is so unfair or unreasonable that it contradicts public policy. The test: if a clause denies a party a reasonable opportunity to enforce their rights, it may be against public policy. Burden of proof: the party opposing enforcement must prove unfairness. Factors courts consider: reasons for non-compliance with the contractual term. Impossibility of compliance may justify non-enforcement. Good faith can influence fairness considerations. Subsequent SCA decisions. The SCA rejected the interpretation that fairness is a standalone requirement in contract enforcement. Courts in Bradenkamp v. Standard Bank of South Africa Limited and Mafango v. Angus Lifestyle Properties analyzed whether cancellations were unfair, but found no unreasonable conduct. In Mafango, the court upheld a lease termination because the landlord acted transparently. Termination was necessary to avoid business losses. No objective basis for claiming unreasonableness or unfairness. Bota v. Rich No, Unfair Cancellation and Constitutional Considerations. Facts: a trust sold property for R240,000 in installments of R4,000 per month. Purchaser paid R180,000, then defaulted. The seller cancelled the contract, resulting in forfeiture of payments. The High Court upheld cancellation, but the Constitutional Court granted leave to appeal. Constitutional Court decision: cancellation and forfeiture of 3/4 of the purchase price was disproportionate and unfair. Seller failed to offer repayment of installments already made. Criticism of the judgment: the court ignored fairness from the seller's perspective, for example, unpaid municipal rates and taxes. The financial loss suffered by the seller was not evaluated. The court failed to articulate clear legal principles for unfair enforcement. Biedeke case clarification. The Constitutional Court later limited Botha's ruling to cases under the Alienation of Land Act, preventing it from having general application. Key ruling: contracts that are not inherently against public policy may still be unenforceable, if their enforcement would be against public policy. Courts must balance individual and public interests. Limits of the defense of unfair enforcement. 1. Exceptio doli generalis, equitable defense of unfairness. Barkhuizen's formulation of unfair enforcement is similar to the exceptio doli generalis. The exceptio doli was an equitable defense against unfair contract enforcement, but was rejected in Bank of Lisbon v. de Ornelis. SCA has explicitly rejected the revival of the exceptio doli after Barkhuizen. 2. Public policy as a boundary for unfair enforcement. Courts recognize public policy as a limit to unfair enforcement. Restraint of trade clauses follow a well-established test of reasonableness, but Barkhuizen's reference to good faith and impossibility suggests a different standard for unfair enforcement. 3. Unfairness must violate a constitutional right or public interest. SCA rulings confirm that unfairness alone is insufficient. Biedeke affirms that a contract's enforcement is only against public policy if it unreasonably limits a constitutional right or public interest. This follows the Sasvin principle, which is firmly established in contract law. Conclusion: courts may refuse to enforce a contract if its enforcement is contrary to public policy, but fairness alone is not enough. The Bota case raised concerns about unfair cancellation, but Biedeke limited its scope to the Alienation of Land Act. The exceptio doli generalis remains rejected, and unfair enforcement is evaluated within the framework of public policy and constitutional rights. Balancing individual and public interests is crucial in determining unfair enforcement. Next. Page 723.6 Unfair enforcement of a contract. Brisley v. Drotsky. Supreme Court of Appeal assumed SASFIN principle could extend to enforcement. Lessee relied on an oral agreement contrary to a non-variation clause in a lease. Lessor accepted late rent for 5 months but later cancelled the lease. Court ruled the case lacked exceptional unfairness, upholding the non-variation clause was justified. Barkhazen v. Napier. Constitutional Court ruled that enforcement of a clause may be refused if it is against public policy. Time limitation clauses must allow reasonable access to courts. The burden of proof is on the party seeking to avoid enforcement. Court suggested impossibility and good faith could determine unfair enforcement. Subsequent case law. Bradenkamp v. Standard Bank of South Africa Limited. Fairness must be considered from both parties' perspectives. Mafango v. Angus Lifestyle Properties. Lease termination upheld. Landlord acted transparently and reasonably. Bota v. Rich No. Purchaser paid 3/4 of purchase price but defaulted. Seller cancelled contract without refunding payments. Constitutional Court found forfeiture disproportionate and unfair. Criticism: Court failed to consider fairness from the seller's viewpoint and ignored precedent in SASFIN. Biedeke decision clarified Botha's application as limited to the Alienation of Land Act. Courts must weigh individual and public interests in enforcing contracts. Enforcement must not unreasonably limit constitutional rights. Limits of unfair enforcement defense. Not equivalent to exceptio doli generalis, rejected in Bank of Lisbon v. de Ornelas. Supreme Court of Appeal affirmed fairness alone does not invalidate enforcement. SASFIN principle applies, enforcement must contravene public policy to be void. 7.2.4 Consequences of a contract void for illegality. 7.2.4.1 Contract cannot be enforced. Ex turpi rule: an illegal contract is void and unenforceable. Ex turpi causa non oritur actio: no claims arise from an illegal contract. No exceptions: courts lack discretion to enforce such contracts. 7.2.2 Severing the illegal part of a contract. Courts may sever an illegal part if 1. It is grammatically or notionally distinct. 2. It is subsidiary to the contract's main purpose. 3. The contract would still be concluded without it. Severance only upheld if all 3 criteria are met. 7.2.4.3 Reclaiming performance under an illegal contract. Par delictum rule. Par delictum rule: if parties are equally guilty, the party in possession has the stronger claim. Courts aim to discourage unlawful agreements. Exceptions to par delictum rule. Plaintiff lacks moral guilt, for example, unaware of illegality or subject to extortion. Minister of Justice v. Van Heerden. State recovered diamonds in an illicit sale trap. Klukov v. Sullivan. Purchaser reclaimed payment despite contract reaching the Liquor Act. Jajve v. Kasim. Court may relax par delictum if enforcing it causes injustice. Factors considered: whether defendant is unjustly enriched, whether relaxing the rule indirectly enforces an illegal contract, public policy considerations, comparison of ex turpi rule and in peri delicto rule. Ex turpi rule in peri delicto rule. Cannot enforce contract, cannot claim restitution of performance. Always applies, has specific applications. Cannot be relaxed, can be relaxed if justified. Next page. 7.2.4 The consequences of a contract that is void for illegality. General rule: an illegal contract is void and cannot be enforced. Severability: if only part of the contract is illegal, it may be severed if certain conditions are met. Performance and restitution: performance under a void contract generally cannot be recovered unless the court allows it. 7.2.4.1 Contract cannot be enforced. Ex turpi rule: ex turpi causa non oritur actio: no action arises from an illegal cause. An illegal contract is void as it lacks a key requirement for validity. Neither party can claim performance or damages. No exceptions: courts lack discretion to relax this rule. 7.2.2 Severing the illegal part of a contract. Severability test: courts assess intention by asking 3 questions. 1. Is the illegal part grammatically/notionally distinct? 2. Is it collateral to the main purpose of the contract? 3. Would the contract exist without the illegal part? If all answers are yes, the illegal part may be severed, allowing the rest of the contract to stand. Public policy exception: even if severance is possible, courts may still void the entire contract. 7.2.4.3 Reclaiming performance, par delictum rule, general rule: restitution is not allowed if both parties are equally at fault. Exceptions: if ownership did not pass, recovery is possible via re vindicatio. If ownership did pass, recovery may be sought under unjustified enrichment. Moral guilt consideration: courts may differentiate degrees of wrongdoing. Key cases: Minister of Justice v. Van Heerden, par delictum rule did not apply, state recovered illicit diamonds. Klukhoff v. Sullivan, par delictum rule applied, contract contrary to Liquor Act. Jadve v. Kasim, par delictum rule relaxed to prevent injustice. Factors courts consider in relaxing the par delictum rule: whether the defendant would be unjustly enriched, whether relaxing the rule would indirectly enforce an illegal contract. Public policy considerations. Comparison: ex turpi rule versus par delictum rule. Ex turpi rule: par delictum rule cannot enforce a contract, cannot claim restitution of performance. Always applies, has a limited scope. Cannot be relaxed, can be relaxed based on circumstances. _ 7.3 Illegal contracts that are valid but unenforceable. Definition: some contracts violate public policy, but remain valid, courts will not enforce them. Effect: a party who performs under such a contract cannot claim restitution. Examples: wagering contracts and contracts in restraint of trade. Why the law treats illegal contracts differently. Contracts affecting society void. Contracts affecting individuals valid but unenforceable. _ 7.3.1 Wagering and gambling contracts. Definition: a wagering contract depends on an uncertain event, where neither party has an independent interest in the outcome. Common law principles. If a party has an independent interest, for example, insurance, conditional donation, the contract is not a wager. Pure wagers are against public interest, valid but unenforceable. 7.3.1.1 The common law on wagering contracts. Wagers are not illegal but unenforceable due to concerns about wastefulness. Cannot be enforced directly or indirectly, for example, by novation or check payments. Exceptions: loans from outsiders to gamblers are enforceable. Loans between bettors for settling debts may be enforced. Loans enabling continued gambling are not enforceable. 7.3.1 to National Gambling Act 7 of 2004. Section 16(1) establishes different rules for gambling debts. Licensed gambling fully enforceable. Unlicensed lawful gambling enforceable only if there is an independent interest. Unlawful gambling probably void. Minors/excluded persons contracts void, winnings forfeitable. Informal bets valid but unenforceable. Comparison: consequences of different wagers. Type of wager: legal consequence. Licensed gambling valid and enforceable. Unlicensed lawful gambling: A. Valid and enforceable if an independent interest exists. B. Valid but unenforceable otherwise. Informal bets valid but unenforceable. Unlawful gambling probably void. Gambling by a minor/excluded person probably void. Next. Page 7.3 to Agreements in restraint of trade. Definition: agreements that limit a person's ability to engage in a profession, trade, or business. Common occurrences: employment contracts: employees agree not to compete with employers after leaving. Sale of business goodwill: sellers agree not to compete with buyers. Partnership agreements: partners agree not to compete with the firm after leaving. Legal conflict: balances sanctity of contract, pacta sunt servanda, against freedom of trade. Traditional approach: before Magna Alloy's case, influenced by English law, restraints were considered void unless the enforcing party could prove reasonableness. Courts prioritize freedom of trade over contractual sanctity. Magna Alloys and Research, S.A., Proprietary, Limited v. Ellis. New approach: restraint agreements are presumed valid unless proven contrary to public interest. Burden of proof, onus, shifted to the party challenging the restraint. Legal status: a restraint that is contrary to public policy is unenforceable, not void. Reddy v. Siemens Telecommunications, Proprietary, Limited. Further clarification: the burden of proof applies only to factual matters, not a broad value judgment of reasonableness. Potential reversal of the burden of proof, onus constitutional issue. Section 22 of the Constitution guarantees the right to choose a profession or trade freely. Some High Court cases suggest the onus should shift back to the enforcing party. However, pacta sunt servanda is also a constitutional value. The Constitutional Court, Barkhazen v. Napier, confirmed that the party alleging unfairness must prove it. Reasonableness test, Basson v. Chilwell. A restraint clause is contrary to public policy if it is unreasonable. Courts consider public interest, contractual interests, and competing rights. 4-step Basson test. 1. Is there a protectable interest? 2. Is that interest threatened by the restrained party? 3. Does the protected interest outweigh the other party's right to trade? 4. Are there broader public policy reasons for enforcing or rejecting the restraint? Even if a restraint is reasonable between the parties, it may still be unenforceable if it harms public interest. Figure 7.1, the Basson test. Refer to original text. Next page. Basson test, detailed analysis of the 4 questions. 1. Is there a protectable interest? Lack of a protectable interest. Restraint is against public policy and unenforceable. Possible exceptions. Reciprocal restraints. Both parties agree to similar restrictions. Direct compensation for the restraint. Types of protectable interests. No exhaustive list, but commonly recognized. Goodwill, trade connections, commercial reputation, and customer relationships. Confidential information, trade secrets, must be 1. Useful in trade/industry. 2. Not public knowledge, known to a restricted group. 3. Economically valuable. Interests not protectable. Capital investments in a joint business. Training costs invested in an employee. Skills and knowledge acquired during employment. Protection against competition itself. An employer cannot prevent a former employee from using their general skills. 2. Is the protectable interest threatened? A direct infringement is not required. A mere risk, if objectively assessed, is sufficient. Examples of threats. Employee joins a competitor. In a similar position, increased risk of confidential information disclosure. Employee has strong customer relationships. Customers may follow them to a competitor. Employee works in a customer-facing role, must join a competing business, in a similar position for a restraint to be justified. 3. Does the protectable interest outweigh the restrained party's right to trade? Balancing test. Does the restraint go further than necessary? Factors considered. Geographical scope. Restraint should be limited to the area where goodwill exists. Time limitation. Customers usually develop new relationships over time, making indefinite restraints unreasonable. Scope of activities. Restraining a salesperson from becoming a bookkeeper in a competing business is unreasonable. Additional considerations. The parties' own views on reasonableness are relevant but not conclusive. Bargaining power matters. Constitutional values of equality and dignity. Courts are more likely to uphold a restraint if both parties had equal bargaining power at contract formation. 4. Are there broader public policy concerns? Public policy beyond reasonableness. Courts usually focus on reasonableness between the parties. No clear precedent where an external public policy reason alone made a restraint enforceable or unenforceable. Theoretical examples, suggested by commentators, not case law. Unreasonable restraint protecting public interest, for example, nuclear scientists' knowledge must remain secret. Reasonable restraint harming public interest, for example, restricting a surgeon with unique skills. Enforcement and partial enforcement. Timing of public policy assessment, Magna Alloys and Research, S.A., Proprietary, Limited v. Ellis. Public interest is assessed at the time of enforcement, not at contract formation. Courts may consider prior and subsequent circumstances, for example, dealings between parties. Probable effects of enforcement. Indefinite enforcement. Restraints may be enforced indefinitely by interdict. However, the restrained party can apply for modification if circumstances change significantly. Partial enforcement of restraints. Magna Alloys case, courts may enforce a reasonable portion of an agreement. Reasons for partial enforcement. Public policy concerns apply to the effect of enforcement, not just the original contract terms. Public interest may favor partial enforcement in some cases. Limitations on partial enforcement. Burden of proof. The party seeking partial enforcement must establish a basis for it. The restrained challenger must prove that even partial enforcement is against public interest. Courts will not rewrite a contract drastically, no major plastic surgery on agreements. Considerations. Was the clause designed to be oppressive or coercive? Would partial enforcement be unduly harsh or unfair? Conclusion. Courts balance contractual sanctity and freedom of trade. Basson test provides a structured framework for assessing reasonableness. Public interest considerations remain flexible and context-dependent. Magna Alloys introduced partial enforcement, but courts limit its application to prevent unfair modifications. Figure 7.2, Mind map of Chapter 7, refer to original text. Next page. Possibility and certainty in contract law. 8.1 Possibility. 8.1.1 General Rule, impossibility prevents obligation creation. If performance of a contractual obligation is impossible, no obligation arises. Impossibility must be objective, meaning no one can perform it, not just the specific party. 8.1 Two different types of impossibility. 8.1.2 Subjective and objective impossibility. Subjective impossibility performance is impossible only for the specific obligor, for example, financial difficulty. Not a valid defense, the contract remains binding. Objective impossibility performance is impossible for anyone, for example, destruction of a unique object. Valid defense, contract is void due to impossibility. 8.1.2 Factual and practical impossibility. Factual impossibility performance is physically or naturally impossible, for example, selling a car that was destroyed. Practical impossibility performance is technically possible but unduly burdensome or impractical, for example, extreme expense or hardship. Courts generally require strong justification for claiming practical impossibility. 8.1.2 Legal impossibility. Performance is legally prohibited, for example, new law criminalizing the obligation. The contract is void due to illegality. 8.1.2.4 Initial impossibility, supervening impossibility, and making performance impossible. Initial impossibility. The obligation was already impossible at contract formation, contract is void. Supervening impossibility. Performance becomes impossible after contract formation, for example, natural disasters can lead to automatic termination of the contract. Making performance impossible, self-induced impossibility. A party deliberately makes performance impossible. That party remains liable and cannot use impossibility as a defense. 8.1.3 Exceptional cases, liability despite impossibility. 8.1.3.1 Contemplation of impossibility and assumption of risk. If a party foresees the possibility of impossibility, but still accepts the risk, they remain liable. Often applies in high-risk commercial contracts. 8.1.3 2 Warranty, guaranteeing performance. If a party expressly or impliedly guarantees performance, they are liable even if performance becomes impossible. Example, a manufacturer warranty ensures product functionality despite defects. 8.1.4 Consequences of impossibility. Contract is void if impossibility existed from the start. Obligation terminates if impossibility arises after formation, unless assumed risk applies. Liability may still arise if a party caused the impossibility. 8.2 Certainty. 8.2.1 General Rule, uncertainty prevents obligation creation. The performance obligation must be clear for a contract to be valid. If uncertainty exists about what must be performed, the contract is void for vagueness. 8.2 Application of the certainty requirement, practical examples. 8.2.2.1 Pactum de contrahendo, agreement to agree, a contract that aims to create another contract in the future, generally unenforceable unless essential terms are sufficiently certain. A mechanism exists to determine missing terms. 8.2.2 Vague language and gaps. If contractual terms are too vague, courts may declare the contract unenforceable. Courts may attempt to fill gaps based on past dealings between the parties, trade customs and practices. 8.2.2.3 Contracts of indefinite duration. If no clear termination conditions exist, courts may interpret the contract as valid but terminable with reasonable notice, invalid if essential obligations are too uncertain. 8.2.2.4 Contracts containing a mechanism for certainty. Some contracts contain built-in mechanisms, for example, arbitration clauses, market-based pricing formulas, to resolve uncertainties. If the mechanism is effective, the contract remains valid. 8.2.3 Consequences of not meeting the certainty requirement. Unenforceability. If essential terms remain uncertain, the contract is void. Court intervention. Courts may attempt to clarify minor ambiguities but will not rewrite essential terms. Next page. Possibility in contract law. 8.1 Possibility. 8.1.1 General Rule, impossibility prevents obligation creation. Impossibilium nulla obligatio est. A contractual obligation must be possible to be valid. A contract is void if the subject matter ceased to exist before contract formation, for example, a destroyed painting. Never existed, for example, land incapable of subdivision. Cannot be legally or commercially disposed of. If parties agree to perform the impossible. No contract is formed if there is no intention to create legal obligations, for example, a joke or lack of mental capacity. If parties intended to create obligations but made a common mistake, the contract may be void due to impossibility. Possibility relates to performance, not to achieving an underlying purpose. For example, buying a frame for a destroyed painting is still a valid contract. A mistake about motive does not invalidate a contract. Does ought really imply can? Traditional view: a party should not be contractually bound to do what is physically impossible. Some legal systems hold a party liable for damages despite impossibility, even though specific performance cannot be enforced. 8.1 Two different types of impossibility. Not all impossibilities prevent contract formation. The nature and timing of impossibility determine its legal effect. 8.1.2.1 Subjective and objective impossibility. Subjective impossibility: the specific party cannot perform, but others can. Does not prevent contract formation. Examples: a party lacks money to pay but payment is still possible. A seller lacks stock but the goods exist elsewhere. Objective impossibility: no one can perform the obligation. Prevents contract formation, for example, destroyed or non-existent object. Inability to use performance does not create impossibility. Example: a traveler books a tour but later cannot obtain a visa. The tour is still available, so the contract remains valid. Consumer Protection Act, Section 17, may allow cancellation. 8.1 2. Factual and practical impossibility. Factual impossibility: performance is physically impossible. For example, an object no longer exists. Practical impossibility: performance is technically possible but would be excessively burdensome. Example, a container of plastic ducks falls into the ocean, but can be retrieved through extreme effort and cost. Courts rarely accept practical impossibility as a defense. Next page. Impossibility in contract law, continued. 8.1, 2.3 Legal impossibility. Performance must be lawful for a contract to be valid. Distinction between impossibility and illegality. If performance is legally impossible at contract formation, is the contract void for impossibility or illegality? Since impossibility flows from illegality, the legality requirement is not met. Case, Wilson v. Smith. Facts: sale of land that could not be subdivided by law. Held, treated as impossibility, not illegality. Examples of legal impossibility. Trading in human tissue is restricted by law. Supervening impossibility due to subsequent legal prohibition. Relevance in claiming restitution. If a contract is void for illegality, the par delictum rule applies, barring restitution in certain cases. If a contract is void for impossibility, the par delictum rule does not apply. 8.1, 2.4 Initial impossibility, supervening impossibility, and making performance impossible. Initial impossibility, performance impossible at contract formation, contract is void. Supervening impossibility, performance becomes impossible after contract formation, obligations may terminate. Example, a house rented by A to B burns down after the contract, the lease terminates. Making performance impossible, fault-based impossibility. If a party deliberately makes performance impossible, the contract remains valid, and the innocent party can claim damages. Cancel the contract. Example, a landlord sets fire to a rented house, still liable for breach. This falls under Chapter 15, Termination of Obligations. Chapter 12, Breach of Contract. 8.1.3 Exceptional cases, liability despite impossibility. 8.1.3.1 Contemplation of impossibility and assumption of risk. General rule: if performance is objectively impossible, no obligation arises. Exception: if parties contemplated impossibility, but did not provide for it, one party may bear the risk. Case, Wilson v. Smith. Facts: sale of land legally impossible to subdivide. Held, contract void under the general rule. Test: did parties contemplate the event making performance impossible? If yes, and they made no contractual provision, the party may bear the risk. What if only one party foresaw impossibility? The innocent party who incurred expenses may claim delictual damages if the other party wrongfully and negligently misled them into believing the contract was valid. 8.1.3.2 Warranty, guaranteeing performance. Warranty: a contract term extending liability beyond normal obligations. Effect: even if performance is impossible, the obligated party remains liable for damages. Types of warranties: express, explicitly agreed upon. Tacit, implied from contract terms or circumstances. Case, S.S. Takler-Bolan, German case. Facts: sale of 1,000 containers of potatoes on a ship. Only 106 were actually on board. Held, seller tacitly warranted that 1,000 containers existed. Result, seller liable for damages due to breach of warranty. Next page. 8.1.4 The consequences of impossibility. General rule: no obligation arises. If performance is objectively impossible, no contractual obligation is created. No claims for performance. Contractual damages for breach. Restitution principle. Anything given in purported fulfillment of the void contract must be returned. This duty is enforceable through unjustified enrichment claims. Reciprocal obligations and impossibility. In reciprocal contracts, where one performance is exchanged for another. If one performance is impossible, the counter-performance is also extinguished. Example: if a painting is destroyed, the obligation to deliver it ceases. Consequently, the buyer has no duty to pay, even though payment is physically possible. Partial impossibility: if only part of the performance is impossible at the time of contract formation. The contract may be invalid in its entirety, or valid for the remaining possible obligations. Key factor: divisibility of performance. Case: Stansfeld v. Kuhn. Facts: contract for 0.5 acres of land for £500. 0.471 acres could be transferred due to a road proclamation. Held. Contract remained valid. Price reduced proportionally to £471. Principle: if performance is divisible, the contract may still be enforced with adjusted counter-performance. If performance is not divisible, the entire contract may be invalid or require proportional adjustment. Next. Page 8.2 Certainty. 8.2.1 The general rule: uncertainty prevents the creation of obligations. A contract must have certain terms or be capable of being made certain using mechanisms in the contract. If obligations are uncertain, no enforceable contract is formed. Practical importance of certainty. Parties may later clarify uncertainties, but problems arise when parties are no longer available to provide explanations. Rights are ceded to third parties who need clarity on obligations. Courts cannot create obligations but can interpret contracts and imply tacit terms. Certainty as a separate requirement from consensus. Debate: is certainty a separate requirement or part of consensus? Traditional view: South African law treats certainty as a separate requirement. Example: parties may agree that a reasonable price must be paid. However, this is legally uncertain, making the contract void. Uncertainty versus lack of consensus. It can be difficult to determine whether invalidity arises due to uncertainty, content unclear, or lack of consensus, no mutual agreement. Example: blank spaces in a contract, void for uncertainty or lack of consensus. _8. 2. Application of the certainty requirement, practical examples. 8.2.2.1 Pactum de contrahendo, agreements to agree. A pactum de contrahendo, contract to enter into a future contract, may be void for uncertainty. If an agreement is provisional and subject to further negotiation, it is too uncertain to create obligations. Valid pacta de contrahendo. Options and preference contracts. Options: future contract terms are already set out, ensuring certainty. Preference contracts: protection mechanisms ensure sufficient certainty. Agreements to negotiate in good faith. If negotiations fail, a valid contract must include a deadlock-breaking mechanism. Southern Port Developments, Proprietary, Limited v. Transnet Limited disputes referred to arbitration if negotiations failed. Makate v. Vodacom, Proprietary, Limited. Employee and employer agreed to negotiate payment in good faith. If negotiations failed, the CEO would determine the amount. Court upheld the agreement but questioned whether the CEO's role was a valid deadlock mechanism. Evolving position on agreements to negotiate. Everfresh Market Virginia, Proprietary, Limited v. ShopRite Checkers, Proprietary, Limited. Constitutional Court suggested that good faith negotiations may be enforceable even without a deadlock mechanism. Implications remain unclear. Makate labeled it a gray area. Roazar CC v. Falls Supermarket CC. SCA took a cautious approach and questioned how good faith negotiations could be enforced without a deadlock mechanism. Memorandum of Understanding, MOU, MOUs may be binding if intended to be binding, sufficiently certain, even if brief. _8. 2. Vague language and gaps. Void for uncertainty. A contract may be void if terms are too vague to determine obligations. Courts try to interpret contracts to ensure validity rather than declaring them void. At res magis valet quam pereat principle. South African law follows the Roman principle. Interpret contracts to be effective rather than destroying agreements. W.N. Hillers & Co. Limited v. Arcos Limited, English law. Law should uphold agreements without violating essential principles. Examples of uncertainty. Levenstein v. Levenstein. Agreement: one party would maintain the other to the best of his ability. Court held this was determinable. Contract upheld. Beretta v. Beretta. Agreement: payment of a substantial sum annually. Court ruled to vague. Contract void. Gaps in contracts. Law supplies default rules for missing terms, such as time and place of performance if not specified. Courts try to fill in gaps where possible rather than voiding contracts. Next. Page 8.2 Certainty. 8.2.1 The general rule: uncertainty prevents the creation of obligations. A contract must have certain or determinable contents to create enforceable obligations. Courts do not create obligations but can interpret and supplement contracts based on the party's actual or presumed intention. The necessity of certainty, as a separate requirement from consensus, is debated. Some argue that uncertainty in performance negates consensus. Traditionally, South African law treats certainty as a separate requirement. A contract may be void due to uncertainty even if the parties subjectively agree. Distinguishing between uncertainty and lack of consensus can be difficult. For example, blank spaces in a contract. 8.2 Application of the certainty requirement. Practical examples. 8.2.2.1 Pactum de contrahendo. Agreement to agree. A contract to enter into another contract may be void due to uncertainty if it is provisional and subject to further negotiation. It depends on the discretion of one party or their attorney. However, valid pacta de contrahendo exist if future terms are predetermined. Options and preference contracts are valid because they establish clear obligations. Agreements to negotiate in good faith can be valid if they include a deadlock-breaking mechanism. Southern Port Developments, Proprietary, Limited v. Transnet Limited. Arbitration was used as a mechanism. Makate v. Vodacom, Proprietary, Limited. CEO was designated to determine payment if negotiations failed. The Constitutional Court, in Everfresh Market, Virginia, Proprietary, Limited v. Shoprite Checkers, Proprietary, Limited, suggested common law might evolve to enforce agreements to negotiate, even without a deadlock-breaking mechanism. The Supreme Court of Appeal, in Roas RCC v. Falls Supermarket CC, was cautious about enforcing such agreements. Memoranda of Understanding, MOUs, are binding if intended as such and sufficiently certain, serve as preliminary agreements before a more detailed contract. 8.2.2 Vague language and gaps. Courts favor interpreting contracts to uphold their validity. At Rees Magis Valley Quam Periot. Levenstein v. Levenstein, a clause requiring support to the best of his ability was upheld. Beretta v. Beretta, an obligation to pay a substantial sum annually was void for vagueness. Contract law provides default rules when parties leave gaps, for example, time and place of performance. 8.2.2.3 Contracts of indefinite duration. Courts enforce indefinite contracts based on parties' actual or presumed intention. Some contracts are terminable by reasonable notice. Some endure for a reasonable period before termination. Some are intended to last indefinitely, though lease agreements cannot be perpetual. Consumer Protection Act, CPA, Regulation 44.3L. A term is presumed unfair if it allows a supplier to terminate an open-ended agreement without reasonable notice, unless the consumer commits a material breach. 8.2.2.4 Contracts containing a mechanism for certainty. It certum est quod certum redi potest. A contract is certain if it provides a means to determine obligations. Mechanisms for certainty. 1. Contractual provisions. Escalation clauses allow adjustments, for example, rental increasing by 10% per year. 2. External standards. Contracts referring to objective price lists, Shell SA, Proprietary, Limited v. Corbett, are valid. 3. Third-party determination. A third party can determine obligations if they act objectively and reasonably. 4. Party discretion. A party cannot unilaterally determine its own performance, conditio si voluero. A party can determine another party's obligations if exercised reasonably. NBS Boland Limited v. 1 Berg River Drive CC. Engen Petroleum Limited v. Commandonique, Proprietary, Limited allowed a lessee to vary rental, provided it was done objectively. Consumer Protection Act Regulations 44(3) J. Certain supplier discretion clauses are presumed unfair. H. Unilateral price increases without the consumer's right to terminate. I. Unilateral alterations to the contract. J. Supplier determining whether goods/services conform to the contract. The issue of price and rental determination. Traditionally, one party could not fix a price or rental. This rule was criticized in NBS Boland. Engen Petroleum allowed a party to vary rental if done objectively. 8. Total consequences of failing the certainty requirement. An obligation failing the certainty requirement is invalid. Severability. If the uncertain obligation is separable, the rest of the contract remains valid. If it is inseparable, the entire contract is void. If a clause benefiting one party is uncertain, courts may allow that party to enforce the contract. Payments made under an invalid obligation can be reclaimed through unjustified enrichment remedies. Next. Page 8.2.2.3 Contracts of indefinite duration. Contracts without a specified duration are valid and enforceable unless uncertainty renders them void. Courts determine validity based on the actual or presumed intention of the parties. Possible interpretations. 1. Termination by reasonable notice. Express or tacit terms may indicate this intention. Courts may infer such a term if a close working relationship is required. 2. Fixed reasonable duration. Contract remains in force for a reasonable period, and then terminates. 3. Perpetual duration. Certain contracts cannot last forever. For example, lease agreements where the lessor must retain ownership. Consumer Protection Act. Regulation 44(3)L, a term allowing a supplier to terminate an open-ended agreement without reasonable notice, is presumed unfair unless the consumer breaches the contract. 8.2.2.4 Contracts containing a mechanism for certainty. Principle, id certum est quod certum redi potest. Something is certain if it can be rendered certain. Certainty mechanisms must function independently of subjective intentions. Methods for ensuring certainty. 1. Reference to an internal mechanism. Example, escalation clauses in rental agreements, for example, annual 10% increase. 2. Reference to an external standard. Shall S.A., Proprietary, Limited v. Corbett, price lists used to determine petroleum prices upheld as valid. Courts have inconsistently treated reasonable price clauses, allowing them for services but not for sales or rental agreements. 3. Determination by a third party. Must be identifiable and exercise discretion reasonably. Courts can adjust manifestly unjust determinations but do not compel the aggrieved party to accept the adjustment. 4. Determination by one party. Conditio si voluero, allowing a party to determine its own performance, is invalid. NBS Boland Limited v. 1 Berg River Drive CC, Deeb v. Absa Bank Limited, Friedman v. Standard Bank of SA Limited. A party can determine the other party's performance if exercised reasonably. Arbitrio bono veri. Clause allowing a bank to vary interest rates upheld. Engen Petroleum Limited v. Commandonique, Proprietary, Limited. Lessee's discretion to vary rental valid if exercised objectively. Consumer Protection Act. Section 15 Supplier may need to provide an estimate and obtain consumer authorization for repairs/maintenance services. Regulation 44(3) J. Certain supplier discretion clauses are presumed unfair, including increasing the price without allowing the consumer to terminate, Unilaterally altering agreement terms. Determining conformity of goods/services with the agreement. _ Why should a party not determine price or rental? Traditional view: South African law does not permit a party to determine its own price or rental, unlike many other legal systems. Criticism: NBS Boland criticized this position, arguing that if a third party can set the price, a contracting party should also be able to do so under reasonable conditions. Engen Petroleum Limited v. Commandonique, Proprietary, Limited, a clause allowing the lessee to vary rental was valid if exercised objectively. _ 8. Total consequences of failing the certainty requirement. Invalidity of obligation: if an obligation lacks certainty, it is void. Severability: if the uncertain obligation can be severed, the rest of the contract remains valid. If it is inseverable, the entire contract is void. Party election: case law supports allowing the party benefiting from the uncertain clause to uphold the contract. Unjustified enrichment: transfers made under a void obligation can be reclaimed. Next page. Study notes, Chapter 8 and 9, Contracts of Indefinite Duration and Parties to Contracts. _ 8.2.2.3 Contracts of Indefinite Duration. Contracts without a specified duration are generally valid and enforceable unless deemed uncertain. Courts interpret these contracts based on the actual or presumed intention of the parties. 3 possible scenarios. Termination by reasonable notice: a contract may include an express or tacit term allowing termination with reasonable notice, especially where parties maintain a close working relationship. Existence for a reasonable period: the contract is intended to remain in force for a reasonable time before terminating. Perpetual duration: some agreements may be intended to endure indefinitely, though certain contracts, for example, leases, cannot legally be perpetual. Consumer Protection Act, CPA, Regulation 44(3)L. A clause allowing a supplier to terminate an open-ended agreement without reasonable notice is presumed unfair, except in cases of material breach by the consumer. _ 8.2.2.4 Contracts containing a mechanism for certainty. It certum est quod certum redi potest: a term is valid if it can be made certain through an independent mechanism. Types of certainty mechanisms. 1. Contractual mechanism for certainty. For example, escalation clauses for rental or supply contracts, for example, rental increases by 10% annually. 2. Objective external standard or mechanism. Shall S.A., Proprietary, Limited v. Corbett, a price preference clause based on the latest ruling price lists was upheld. South African law inconsistently allows service contracts at a reasonable price, but traditionally disallows sales or leases based on a reasonable price. 3. Third-party determination. Valid as long as the third party is identifiable and exercises discretion objectively and reasonably. Courts may adjust manifestly unfair determinations but do not impose a duty on the aggrieved party to accept an adjusted performance. 4. Party discretion. A party may not fix its own performance, conditio si voluero. NBS Boland Limited v. 1 Berg River Drive CC. A contractual party may determine the other party's performance unless fixing its own prestation. A mortgage bond clause allowing a bank to vary interest rates was upheld, provided the discretion was exercised reasonably. Arbitrio bono viri. Consumer Protection Act. Section 15. A supplier may need to provide an estimate and obtain prior authorization for repairs/maintenance. Regulation 44(3)H. J. Terms allowing unilateral supplier discretion over price changes, contract terms, or compliance assessments are presumed unfair. _ 8. Total consequences of failing the certainty requirement. An uncertain obligation is invalid. Severability rule. If the uncertain obligation is severable, the rest of the contract remains valid. If inseverable, the entire contract is void. Unjustified enrichment. Transfers made under an invalid obligation can be reclaimed. Case law, some support for allowing the party benefiting from an uncertain clause to elect to uphold the contract. Chapter 9, Parties to Contracts. 9.1 Number of parties. Contracts require at least 2 parties, as agreement presupposes mutual intent. Unilateral declarations are not contracts in South African law, a person contracting with themselves. Possible if acting in 2 capacities, for example, as an agent of a company and in a personal capacity. Courts may disregard sham contracts intended for tax evasion or fraud. 9.2 Multiplicity of parties. A contract may involve multiple parties, with various rights and obligations. Determination of liability and entitlement depends on intentions of the parties, nature of the contract, divisibility of performance. 9.2.1 Divisibility of performance. Divisible performance. For example, a seller sells 100 cows to 2 buyers, each entitled to a portion. Indivisible performance. For example, a seller sells a single cow to 2 buyers requiring joint entitlement. Subjective divisibility. Even physically separable items, for example, rare paintings, may be indivisible if intended to be sold as a unit. 9.2 Simple joint liability and entitlement. Presumption: if multiple debtors owe a divisible performance, liability is joint, not joint and several. For example, if 5 debtors owe R5,000, each is liable for R1,000 unless stated otherwise. Release of one debtor does not automatically release others unless intended. Overpayment by one debtor. Recovery depends on contractual agreement or unjustified enrichment. 9.2.3 Joint and several, in solidum, liability and entitlement. Key feature: each debtor is individually liable for the full debt. Applies in express agreement, partnerships, co-signatories of negotiable instruments, statutory obligations. Creditor's right can claim full performance from any debtor. If one debtor pays in full, others are discharged. If partial payment is made, the creditor can claim the remainder from others. Right of recourse. A paying debtor can recover proportionate contributions from co-debtors. Release of one debtor. Remaining debtor's liability is proportionately reduced. 9.2.4 Collective joint liability and entitlement. Performance must be jointly delivered or received as a group. No single debtor or creditor can act alone. Example: A and B co-own a farm and sell it to C. C must claim transfer from A and B together, not separately. 9.2.5 Several liability. Multiple independent contracts may be consolidated in one document, but remain separate obligations. Common in construction projects where subcontractors handle different tasks. 9.3 Contracts and third parties. 9.3.1 Privity of contract. A contract only binds its parties unless an exception applies. 9.3.2 Representation, contracting through an agent. 9.3.2.1 Relationship between principal and agent. Express or implied authority required. Agent must act within scope to bind the principal. 9.3.2 Relationship between principal and third party. A properly authorized agent binds the principal to the third party. 9.3.2.3 Relationship between agent and third party. An agent acting within authority has no personal liability unless acting on their own behalf. 9.3.3 Contract for the benefit of a third party. Stipulatio alteri, a contract may be made in favor of a third party. Third party must accept the benefit to enforce it. 9.3.4 Transfer of rights and duties to a third party. Cession, transfer of rights, and delegation, transfer of duties, may occur with consent. 9.3.5 Performance by a third party. A debtor may have a third party perform unless the contract requires personal performance. Underscore. 9.3.6 Performance made to a third party. A creditor may instruct performance to be made to a third party. Underscore. This summary captures the key legal principles and cases from Chapter 8 and 9 while ensuring depth and conciseness. Let me know if you need further details on specific sections. Rocket emoji. Next page. Chapter 9, Parties to Contracts, Birgit Kusht and Dale Hutchison. 9.1 Number of parties. A contract requires at least 2 parties as it is based on agreement and mutual intent. Unilateral promises are not binding in South African law. A person may contract with themselves in different capacities, for example, as an agent of a corporation contracting with themselves personally. Courts will disregard sham contracts created for fraudulent purposes, such as tax evasion. 9.2 Multiplicity of parties. Contracts often involve more than 2 parties. Obligations and entitlements must be determined per party. Each contract creates multiple obligations, with at least one debtor and one creditor for each obligation. Co-debtors and co-creditors must determine their share of liability or entitlement based on intent, contract nature, and divisibility of performance. 9.2.1 Divisibility of performance. Divisible performance can be apportioned among multiple parties, for example, sale of 100 cows to 2 buyers. Indivisible performance cannot be split, for example, sale of a single cow to 2 buyers. Intention of the parties may render a performance indivisible, even if physically separable, for example, a rare painting collection sold as a unit. 9.2 Simple joint liability and entitlement. If debtors share a divisible obligation, the presumption is joint liability, with each debtor responsible for an equal portion. Example, if 5 debtors owe R5,000, each is liable for R1,000, unless otherwise agreed. Creditors sharing an entitlement to a divisible performance each receive an equal share unless agreed otherwise. Release of one debtor does not automatically release others unless intended by the creditor. A joint debtor who pays more than their share may only recover the excess from others if an agreement or unjustified enrichment applies. 9.2.3 Joint and several, in solidum, liability or entitlement. Unlike simple joint liability, each co-debtor is liable for the full debt. A creditor may claim the entire debt from one or more debtors. If one debtor pays the full amount, they have a right of recourse against co-debtors for their proportional share. By law, certain relationships impose joint and several liability, for example, partnerships or co-signatories on negotiable instruments. Benefit to creditor can claim full performance from a financially strong debtor, leaving them to recover from others. If a co-creditor is entitled to performance, any one of them can claim it in full, discharging the debtor's obligation. 9.2.4 Collective joint liability and entitlement. Debtors must perform jointly and creditors must claim performance together. Arises when performance is indivisible and parties intend collective liability. Example, if co-owners sell a farm, the buyer can only demand joint transfer from both, not separately. 9.2.5 Several liability. Each debtor is independently liable for their own obligation, without being responsible for co-debtors' performance. Occurs when multiple parties enter into separate contracts under a single document, for example, subcontractors in construction projects. 9.3 Contracts and third parties. Brevity of contract dictates that a contract only binds its immediate parties. However, third parties may be involved as agents negotiating on behalf of a principal, as substitutes for original parties, as beneficiaries of a contract. 9.3.1 Brevity of contract. Contracts do not impose obligations on third parties without consent. However, third parties may acquire rights under a contract if the contracting parties agree to confer benefits on them. Interference by third parties may be wrongful. Inducing breach of contract can be a delict, for example, an employer poaching an employee in breach of contract. A third party acquiring property in bad faith may be bound by contractual obligations of the previous owner, for example, knowing about a servitude but ignoring it. 9. The 3-2 representation, contracting through an agent. Many contracts are concluded through agents, particularly for juristic persons like companies. Agency versus mandate. Agency involves authority to conclude binding contracts on behalf of a principal. Mandate merely involves performing a task, for example, an estate agent finding a buyer, but not selling the house on behalf of the owner. Authority to represent may arise from law, for example, a director acting for a company. Contract, conventional representation, for example, power of attorney, power of attorney. General, broad authority over all matters. Special, limited authority for specific transactions. Legal consequences of agency involve the relationships between principal P and agent A, principal P and third party 3P, agent A and third party 3P. Next page. 9.3 Contracts and third parties. Contracts typically create rights and duties only for the contracting parties. Third parties may be involved in contract formation, performance, or substitution of parties. The privity of contract principle restricts third-party rights and obligations but has some exceptions. 9.3.1 Privity of contract. Contracts create personal rights and duties only for the contracting parties. No duties can be imposed on third parties without their consent. Rights may be conferred upon third parties if agreed upon by the contracting parties. Third-party interference may lead to liability, for example, inducing breach of contract. Under doctrine of notice, a third party who acquires property in bad faith may be bound by prior contractual obligations. 9. The 3-2 representation, contracting through an agent. Many contracts involve agents acting on behalf of principals. An agent, A, negotiates and concludes contracts on behalf of a principal, P, with a third party, 3P. The contract exists between P and 3P, while A is not a party to the contract. Types of representation. Juristic representation, authority granted by law, for example, guardian for a minor, director for a company. Conventional representation, authority granted by P to A via agreement, for example, power of attorney, power of attorney. General, broad authority, or special, limited authority. Mandate versus agency. Mandate, a task assigned without power to conclude contracts. Agency, includes mandate plus authority to contract on P's behalf. 9.3.2.1 Relationship between principal and agent. Governed by common law mandate principles and contractual terms, a fiduciary relationship requires A to act solely in P's best interests. Statutes may impose specific duties on agents or intermediaries. 9.3.2 Relationship between principal and third party. Consensus depends on a state of mind, not P's, since A negotiates for P. P is vicariously liable for as acts, including misrepresentation, authority of A. If A acts within authority, contract binds P and 3P. If A lacks authority, P is not bound but may be liable for unjust enrichment. Situations where P is bound despite as lack of authority. 1. Ratification. P later approves as unauthorized act, retroactive effect. 2. Agency by estoppel. P misrepresents that A has authority, 3P relies on it, and 3P suffers prejudice. 3. Ostensible authority, Makate v. Vodacom, Proprietary Limited. If P creates the appearance that A has authority, P is bound, no further estoppel requirements. Criticism: the decision diverges from prior case law and may allow contracts despite 3P's knowledge of as lack of authority. Doctrine of undisclosed principle. If A contracts in their own name but secretly for P, P may later enforce the contract against 3P. 3P may choose to enforce the contract against either A or P, but the choice is final. Cullinan v. Norcaplans or Tapolcamo Cookers Corpus EBPK, upheld this doctrine despite inconsistencies with fundamental legal principles. Unidentified principle. A informs 3P that they act for P but does not disclose P's identity. The contract is between 3P and P. Non-existent principle. At common law, contracts cannot be concluded on behalf of non-existent entities. Exception: pre-incorporation contracts allow contracting for a yet-to-be-formed company, provided statutory requirements are met. 9.32.3 Relationship between agent and third party. If A acts within authority, they incur no liability to 3P. If A exceeds authority or lacks authority, they may be liable to 3P. Breach of warranty of authority. A is contractually liable and damages are based on 3P's positive interest. Delictual liability, misrepresentation. A is liable for fraud or negligence and damages are based on 3P's negative interest. Legal fiction of implied warranty of authority may no longer be justifiable after the development of delictual liability. Next. Page 9. Relationship in agency. 9.32.1 Relationship between principal and agent. Governed mainly by common law principles of mandate and supplemented by agreed terms. Agent has a fiduciary duty to act in the principal's best interests. Some statutes impose specific duties on agents/intermediaries. 9.32 Relationship between principal and third party. Consensus determination, based on the agent's A. state of mind as they negotiate for the principal, P. Vicarious liability, P is responsible for as actions including innocent misrepresentations. Authority of A. If A acts within authority, P and the third party, 3P, are bound. If A exceeds authority, P is not bound but may be liable for unjust enrichment. Exceptions where P is bound despite lack of actual authority. 1. Ratification. P adopts as contract retroactively if A acted as an agent and P existed at the time of contract formation. 2. Estoppel agency by estoppel. P is prevented from denying as authority if P misrepresented that A had authority. 3P reasonably relied on that misrepresentation. 3P would suffer prejudice if P denied the contract. 3. Ostensible apparent authority, based on Makate v. Vodacom, Proprietary, Limited. If P creates an appearance that A has authority, P is bound. Previously equated with estoppel, but Makate ruled that misrepresentation alone suffices. Minority judgment. Wallace A.J. criticized this approach as inconsistent with prior case law. Undisclosed principle doctrine. A contracts in their own name but secretly acts for P. A is personally liable but P can demand performance from 3P unless 3P has already performed to A. If 3P discovers P's identity, they can choose to claim performance from either P or A. Decision is final. Recognized in Cullinan v. Norcaplans or Tapolcamoa Cookers, Culpracy BPK despite inconsistency with fundamental legal principles. Unidentified principle. A informs 3P they act for P, but does not disclose P's identity. Contract is binding only between 3P and the unidentified P. Representation of a non-existent principal. Common law prohibits acting for a non-existent P, for example, unborn child. Such contracts are void ab initio and cannot be ratified later. Pre-incorporation contracts are an exception, allowing contracting for a company yet to be formed, provided statutory requirements are met. 9.32.3 Relationship between agent and third party. General rule: if A acts within authority, they are not liable to 3P. Agent's liability. If A lacks/exceeds authority, they may be liable to 3P for losses due to contract failure. Warranty of authority. If A promised they had authority but did not, they are liable for breach of warranty. Misrepresentation. Fraudulent/negligent misrepresentation liability in delict. Previously, courts used an implied warranty of authority to impose liability. Question remains whether this legal fiction is still justified. 9.3.3 Contract for the benefit of a third party. Stipulatio alteri. a contract may grant rights to a third party, C, who is not a contracting party, common in pension agreements, life insurance policies, and inter vivos trust deeds. Roman law initially prohibited third-party stipulations, but Roman Dutch law accepted them with differing views on third-party rights. South African courts consistently enforce such contracts. Elements of stipulatio alteri. Valid formation. A. Stipulans, contracts with B, permittens, to confer benefit on C. C need not exist at the time of contract formation, for example, unborn child, future company. Intention to create rights. The contract must establish an enforceable obligation for C. Incidental benefits do not suffice. Third-party acceptance. C gains rights only upon notifying B of acceptance. Before acceptance, A and B may alter or cancel the contract. Rights of A. A cannot demand personal performance, but can ensure B adheres to their promise. After C accepts, A generally loses rights under the contract. Rights of C. Upon acceptance, C acquires an independent right to enforce performance against B. Legal relationship post-acceptance depends on contract terms. Reciprocal obligations. If the benefit includes obligations, for example, purchase of property, C must accept both benefit and obligation. Legal debate on stipulatio alteri. Dual contract theory, majority view. First contract, A and B. Second contract, B and C upon C's acceptance. As rule depends on the terms, A may remain bound even after C accepts. Single contract theory, DeWitt's view, less favored. Only one contract between A and B. C's right arises directly but remains inchoate until acceptance. C's acceptance confirms the right, but does not form a separate contract. Similar to European contract law. Ongoing debate. Key question: when does C acquire a right? Implications for insolvency, succession, insurance, and cession law. Next. Page 9.3.3 Contract for the benefit of a third party, stipulatio alteri, practical legal consequences. Insolvency of the third-party beneficiary. If the right to the benefit arises only upon acceptance, it does not form part of the beneficiary's insolvent estate before acceptance. If the right exists prior to acceptance, it may be included in the insolvent estate. Theoretical justification. The idea that a third party acquires a contractual right from an agreement between two others contradicts traditional contract principles, which focus on consensus and the bilateral nature of contracts. The more widely accepted view is that the stipulatio alteri creates an offer to the third party, and only upon acceptance does a new contractual relationship arise. This approach aligns with contract law fundamentals and ensures that the stipulans, A, retains legal recourse if the permittens, B, fails to uphold the agreement. 9.3.4 Transfer of rights and duties to a third party. General principle. Contractual rights and duties can be transferred to a third party but often require the consent of the original parties. Transfer of rights, cession. Definition: a transfer agreement where a creditor, cedent transfers a right to a third party, cessionary, who replaces them as creditor. Requirements. Consent of the cedent and cessionary is required. The debtor's consent is not required. General rule: contractual rights are freely transferable unless the right is intuitu personae, personal in nature. The contract expressly prohibits cession, pactum de non cedendo. Judicial explanation in a CJ. If cession substantially alters the rights or obligations of the debtor, consent may be required. Subject to exceptions, rights of action are freely assignable. Transfer of duties, delegation. Definition: the substitution of debtors, where the original debtor transfers their obligation to a third party. Requirements: all parties must consent, the creditor, original debtor, and new debtor. Traditional view: delegation always results in novation, extinguishing the original obligation and creating a new one. Modern view: a debt may be transferred without novation, but this remains unsettled. Full transfer of rights and duties assignment. Definition: a party is substituted by a third party in a contract by transferring both rights, cession, and duties. Delegation. Mechanism. Requires a tripartite agreement between all affected parties. Alternatively, the original contract is extinguished and a new one is created. Novation. _ 9.3.5 Performance by a third party. A third party may perform an obligation on behalf of a contracting party. Legal effect. The third party does not become a party to the contract. The original debtor remains liable unless explicitly released. _ 9.3.6 Performance made to a third party. Adjectus solutionize causa: a debtor may, by agreement, discharge their obligation by performing to a third party. Legal effect. The third party does not become a creditor. The third party cannot demand performance or act as an agent of the creditor. Next. Page 10. Obligations and terms. 10.1 Introduction. Previous chapters covered contract validity and parties. This chapter focuses on obligations arising from a contract, terms that define or qualify these obligations. While contracting parties determine much of the contract's content, some terms arise by operation of law. _ 10.2 Obligations. 10.2.1 Classification of obligations. Obligations can be classified based on their nature and enforceability. Types include civil, natural, moral, reciprocal, simple, alternative, generic, facultative, divisible, and indivisible obligations. 10.2 Civil, natural, and moral obligations. Civil obligations, legally enforceable. Natural obligations, not legally enforceable, but may have moral or social significance. Moral obligations, not legally binding, but can influence judicial decisions or contractual interpretations. 10.2.3 Reciprocal obligations. Mutual duties where the performance of one party is dependent on the performance of the other. Common in bilateral contracts, for example, sale contracts: seller must deliver goods, buyer must pay. 10.2.4 Simple, alternative, generic, or facultative obligations. Simple obligations require performance of a single, specific act. Alternative obligations, debtor may choose between multiple possible performances. Generic obligations, performance involves an item of a certain type, not a specific object. Facultative obligations, debtor is bound to a specific performance but may substitute it with another. 10.2.5 Divisible or indivisible performances and contracts. Divisible performance can be executed in parts, for example, installment payments. Indivisible performance must be executed as a whole, for example, delivery of a unique item. Effect on contracts, breach and remedies depend on whether the performance is divisible. _ 10.3 Terms. 10.3.1 Essentialia, Naturalia, Incidentalia. Essentialia, essential terms defining the type of contract, for example, price in a sale contract. Naturalia, terms implied by law unless excluded by the parties. Incidentalia, additional terms specifically agreed upon by the parties. 10.3 Express terms. Explicitly agreed upon by the parties. Include signed contracts, standard form contracts, unsigned documents, ticket cases, notices, statutory provisions, and prohibited terms. 10.3.2 Unsigned contracts, caveat subscripta rule. Let the signer beware, a person who signs a contract is bound by its terms, even if they did not read them. Exceptions: misrepresentation, fraud, undue influence or mistake. 10.3.2 Standard form contracts. Pre-drafted contracts used in commercial transactions often favor the party that drafted the contract, for example, service providers, banks. Courts may intervene if terms are unfair or unconscionable. 10.3.2 Unsigned documents. A party may still be bound if they had reasonable notice of the terms. 10.3.2.4 Ticket cases. Cases where terms are contained in tickets, for example, transport or event tickets. The ticket holder is bound if they had reasonable notice of the terms. 10.3.2.5 Notices. Terms displayed on signboards or disclaimers, binding only if reasonable steps were taken to bring them to the party's attention. 10.3.2.6 The Consumer Protection Act 68 of 2008 protects consumers from unfair, unreasonable, or unjust terms, requires clear and understandable language in contracts. 10.3.7 Terms prohibited by law. Some terms are unenforceable due to public policy or statutory prohibition, for example, terms violating constitutional rights. 10.3. Tacit contracts. A contract inferred from conduct rather than explicit agreement. 10.3. The implied terms. Terms not expressly agreed upon, but included by law or necessity. 10.3.1 Terms implied ex lege. Imposed by law, such as the implied duty of good faith in employment contracts. 10.3.3.2 Tacit terms. Inferred from circumstances where the parties would have agreed, had they considered the issue. 10.3.4 Material terms. Fundamental terms without which the contract would not exist. Breach of a material term may justify cancellation of the contract. 10.3.5 Conditions and their effect on the contract. Conditions affect the existence or performance of obligations. 10.3.5.1 Positive and negative conditions. Positive condition requires an event to occur before an obligation arises. Negative condition requires an event not to occur. 10.3.5 To suspensive and resolutive conditions. Suspensive condition, contract only takes effect if a certain event occurs, for example, loan approval in a property sale. Resolutive condition, contract is terminated upon the occurrence of a certain event, for example, employment until retirement. 10.5.3 Potestative, casual, and mixed conditions. Potestative condition depends on the will of one party, for example, a subject to my approval clause. Casual condition depends on an external event, for example, a lottery draw. Mixed condition depends on both a party's will and an external event. 10.5.4 Interference in the fulfillment of conditions. A party cannot deliberately prevent a condition from being fulfilled if it benefits them. 10.6 Time clauses. Specifies when performance is due. Types. Dies certis, fixed date for performance. Dies incertus, uncertain future date. 10.7 Other common contractual terms. 10.7.1 Suppositions. Assumptions or conditions upon which a contract is based. 10.3.7 2 Modal clauses. Imposes specific modes of performance. 10.3.7.3 Exemption clauses. Limits liability for breach of contract or negligence, subject to judicial scrutiny if unfair or unreasonable. 10.7.4 Non-variation clauses. Prevents oral or informal modifications to the contract, generally enforceable unless overridden by statute or good faith requirements. 10.7.5 Governing law clause. Specifies which legal system applies in case of dispute. Next page. 10.2 Obligations. Definition: a legal bond between two or more persons, comprising both a right, creditor's claim, and a duty, debtor's obligation to perform. Personal rights versus real rights. Contractual obligations create personal rights, enforceable only against the other party. Real rights are enforceable against the world at large. 10.2.1 Classification of obligations. Obligations can overlap in classification. Example: a contractual obligation to deliver a table lamp may be civil, legally enforceable; simple, specific performance required; reciprocal, exchange-based; indivisible, must be performed in full. 10.2 Civil, natural and moral obligations. Moral obligations. Not legally binding, for example, keeping a promise to meet a friend, derived from social norms or conscience. Civil obligations. Legally enforceable, a creditor can sue if breached. Most contractual obligations fall under this category. Natural obligations. Not enforceable in court but have some legal recognition. Examples: contracts with minors. A minor has a natural obligation, but the other party has a civil obligation. Betting agreements or wagers cannot be legally enforced, but if performance occurs, it cannot be reclaimed. Legal consequences can be set off against a civil obligation. If performance occurs, it is considered valid and binding. 10.2.3 Reciprocal obligations. Most contracts involve reciprocal obligations, meaning two performances are exchanged. Example: contract of sale. Purchaser must pay the purchase price. Seller must deliver the goods. Neither party must perform unless the other does. 2 roles per party. Each party is both a debtor, owing performance, and a creditor, entitled to performance. Example: buyer equals debtor, owes payment, plus creditor, entitled to delivery. Seller equals debtor, owes delivery, plus creditor, entitled to payment. 10.2.4 Simple, alternative, generic, or facultative obligations. Simple obligations. Performance is precisely specified at contract formation. Example: seller must deliver a car with registration CA 123,456. Alternative obligations. Performance is chosen from 2 or more options. Example: seller must deliver either cow Annabelle or cow Bluebell. Who chooses? The debtor chooses unless otherwise agreed. If not specified, the obligation might be void for vagueness. Once a choice is made, the obligation becomes simple, i.e., only the selected performance can be enforced. Generic obligations. Performance is not a specific item, but from a genus, category. Example: seller must deliver 3 Ngani cattle. Choice of performance. Parties must specify who decides. If not stated, debtor makes the choice. Facultative obligations. Primary performance is specified, but the debtor may substitute another if they choose. Example: seller must deliver cow Annabelle, but may choose to deliver Bluebell instead. Difference from alternative obligations. In alternative obligations, the creditor can claim any selected performance. In facultative obligations, the creditor can only claim the primary performance, Annabelle, never the alternative, Bluebell. Next. Page 10.2.5 Divisible or indivisible performances and contracts. Definition of obligation: a legal relationship between a creditor and debtor regarding a specific performance. Number of obligations. If a contract involves multiple performances, it creates multiple obligations. The number of obligations depends on the number of distinct or indivisible performances. Divisible versus indivisible performances. Divisible performance can be split into multiple independent performances. Example: building a shopping center can be divided into land preparation, construction, plumbing, etc. Each separate performance creates a separate obligation. Indivisible performance cannot be meaningfully divided. Example: delivery of a horse must be delivered as a whole. Creates a single obligation. Contractual consideration. Even if a performance is divisible by nature, it may still be indivisible by intent. Example: delivery of a pair of horses. Naturally divisible, each horse can be delivered separately. But if parties intend them to be treated as a unit, the performance is indivisible. Divisible versus indivisible contracts. Divisible contract can be split into separate contracts, each containing its own obligations. Example: a contract with multiple obligations, each treated as an independent agreement. Legal consequences. Each part of the contract must meet validity requirements. For example, if only one part is defective, the rest remains valid. Breach of contract applies separately. If a party breaches one part, the aggrieved party may cancel only that part. _ 10.3 Terms. Definition. Stipulations included by parties. Provisions implied by law. Effect. Determine the legal consequences and obligations. Parties are generally free to set their terms within legal limits. Overlapping classifications. A term may be express, an incidental, and an exemption clause at the same time. _ 10.3.1 Essentialia, Naturalia, and Incidentalia. Essentialia. Definition. The key terms that define a specific contract type. Determine whether a contract falls into a recognized category, for example, sale, lease, loan. Examples: contract of sale, transfer of property in exchange for money. Contract of lease, right to use property in exchange for rent. Naturalia. Definition. Terms automatically included by law in a specific type of contract, implied by law, ex lege. Protect parties from typical risks. Examples: contract of sale, seller is liable for latent defects, protects buyers. Lease agreement, landlord's tacit hypothec, allows attachment of tenant's property for unpaid rent. Modification. Parties may exclude naturalia by agreement. Example: Voetstud's clause excludes liability for latent defects. Legal control over exclusion clauses. Courts interpret ambiguous clauses narrowly, contra proferentem. Legislative restrictions. National Credit Act prohibits waiving common law rights in credit agreements. Consumer Protection Act prevents exclusion of liability for gross negligence. Incidentalia. Definition. Additional agreed terms that modify or supplement the naturalia. Examples: buyer pays a delivery fee, interest on late payments, exemption from liability for defects. _ Next. Page 10.3 Express terms. Definition: terms specifically agreed upon by the parties, either orally or in writing. Formation of contract. If the parties do not intend writing to be a requirement, the contract is concluded when they reach consensus or one party reasonably relies on the appearance of consensus. If writing is required for validity, the contract only exists when the terms are reduced to writing and signed. _ 10.3.2 Signed contracts, caveat subscripta rule. General rule. A party who signs a written contract is bound by its terms, even if they have not read or understood them. Based on caveat subscripta, let the signatory beware. Purpose. Protects the reliance interest of the other party. Ensures commercial certainty. Exceptions. Use error, fundamental mistake, regarding contract contents, contract nature, identity of the parties, unreasonable reliance on the appearance of consensus, consent defects, misrepresentation, duress, undue influence, commercial bribery, balance of interests. Law ensures certainty in contracts while protecting parties who sign due to error or coercion. _ 10.3.2 Standard form contracts. Definition. Pre-drafted contracts used by large corporations and public utilities. Terms are often non-negotiable. Legal considerations. A party presenting such a contract must highlight unexpected terms. If not, the party may argue that they were unaware of the unusual term, and it may not be binding. _ 10.3.2 Unsigned documents. Express terms can be incorporated by reference. Contractual documents may refer to terms in another document. Example: insurance contracts. Main contract signed, but refers to separate terms and conditions in an unsigned document. _ 10.3.2.4 Ticket cases. Incorporation by reference. If a ticket refers to terms in another document, the customer is bound if they knew the ticket had writing. They knew the writing contained contractual terms. if the customer was unaware of the writing or its significance. The issuer must take reasonable steps to inform them. Legal test from English law. Did the customer know the ticket contained writing? Did they know the writing contained contract terms? If not, did the issuer take reasonable steps to notify them? If these conditions are met, the customer is bound. Types of documents. Expected to contain contract terms. Tickets for transport, airline, bus, train. Event admission tickets. Not usually contractual, and require greater notice. Invoices. Warehouse receipts. _ This structured breakdown ensures clarity while maintaining depth. Let me know if you need modifications. Next. Page 10.3.2.5 Notices. Definition. Express terms posted as notices, for example, exemption or owner's risk clauses, to exclude liability for negligence. Common in parking garages, shopping centers, and public venues. Common law rules. Binding if the user was aware of the notice. The notice was conspicuously displayed, so awareness is inferred. If the user was not aware, the service provider may still escape liability if they took reasonable steps to notify the user. Same legal principles as ticket cases. Strict interpretation. Exemption clauses are strictly construed. Given minimum effect, exempting only ordinary negligence, not gross negligence. Cannot exclude liability for fraud, public policy. _ 10.3.2.6 The Consumer Protection Act, CPA, 68 of 2008. Purpose. Protects consumers by requiring clear notice of terms that may be prejudicial. Categories of notices requiring attention. Limits supplier's liability or risk. Indemnifies the supplier, for example, parking garage notice stating no liability for vehicle damage. Transfers risk to the consumer, for example, shopping center notice stating entry is at own risk. Precludes claims based on prior representations. Legal requirements for validity. Plain language must be used. The consumer must be alerted before entering the contract, or paying for goods or services. Must be conspicuously displayed to attract an ordinarily alert consumer. Consumer must have a reasonable chance to understand it. Serious or unexpected risks. Includes risks that are unusual or not obvious. Could lead to serious injury or death. Additional requirement. Consumer must assent by signing or by other conduct acknowledging the risk. _ 10.3.7 Terms prohibited by law. Limits to freedom of contract. Immoral or contrary to public policy equals unenforceable. Exclusion of liability for fraud equals not permitted. No general requirement of fairness in contracts. Statutory prohibitions and penalties. A term conflicting with statutory prohibition may be invalid. If a law imposes a penalty for an act, the transaction is typically void unless this would cause grave consequences. Judicial modification on fair terms. Some laws empower courts to modify unfair contract terms. Conventional Penalties Act allows courts to reduce excessive penalties for breach of contract. Courts can lower penalties that are disproportionate to the actual harm suffered. Ensures penalties are reasonable and fair. _ Next. Page 10.3. Tacit contracts. Definition and characteristics. Inferred from conduct, rather than explicit agreement. Some scholars argue that terms expressed by conduct can also be considered express terms. Example: when a lease expires, but the lessee remains in occupation, and the lessor continues to accept rent, a new contract is inferred from their conduct, regardless of intent. Conceptual challenges. Unclear basis. Debate on whether tacit contracts arise from actual consensus or reasonable reliance. Christie's view. Tacit contracts are based on actual consensus inferred from facts, not reasonable reliance. Problem. Tacit contracts have been found where one party was mistaken, which contradicts the idea of actual agreement. Some cases suggest tacit contracts are based on objective approaches to contractual liability rather than subjective agreement. Legal test for tacit contracts. Traditional test, Standard Bank v. Ocean Commodities. Must show unequivocal conduct that can only be interpreted as a contract. Requires proof of consensus ad idem, meeting of minds. Less onerous test, Joel Melamed and Hurwitz v. Cleveland Estates. Tacit contract exists if the most plausible conclusion from all facts is that a contract came into existence. Final position, Buffalo City v. Nurture Development Finance. Settled test. Tacit contract exists if there is unequivocal conduct leading to an inference of consensus on a balance of probabilities. Onus of proof is the same as for any other contract, balance of probabilities. Unresolved issues. Are tacit contracts based on actual consent or imposed based on objective considerations? Do tacit contracts belong to the category of express terms, since they arise from conduct rather than explicit articulation? This version maintains concise yet detailed coverage of the key points, ensuring clarity and structure. Let me know if you need modifications. Next. Page 10, 3.3 Implied terms. Definition. Terms that are not explicitly agreed upon, but still form part of the contract. Implied by operation of law, ex lege, custom or trade usage. Facts surrounding the agreement, ex consensu. _. 10, 3.3.1 Terms implied ex lege. General characteristics. Imposed by law, operating unless expressly excluded by the parties. Can be overridden by agreement, except in certain statutory cases. Considered naturalium of a contract, regulating terms the parties may not have considered. Terms implied by common law. Certain terms are incorporated into all contracts of a particular type. Examples: employment contracts, employee's duty of good faith, and employer's duty to remunerate. Loan contracts, borrower's duty to return borrowed items. Innkeepers, liability for theft of guests' belongings. Sale of business, buyer's right to restrict seller from canvassing customers. Indefinite contracts, right to terminate with reasonable notice. Employment contracts, Murray v. Minister of Defense, employer's duty to deal fairly with employees. Courts may add to this list as common law evolves. Exclusion of implied terms. Generally allowed, except for statutory exceptions. Ambiguity is interpreted against the party that drafted the exclusion clause. Terms implied by statute. Reason for statutory intervention. Common law failed to address modern issues like standard form contracts and digital agreements. Contracts are now easier to enter into, increasing the risk of unfair terms. Labor law, Basic Conditions of Employment Act. Contracts of employment include implied statutory terms unless more favorable terms are agreed. Covers aspects like working hours, leave, remuneration. Some statutory terms can be varied, while others cannot. Credit agreements, National Credit Act, governs credit agreements, ensuring fairness. Key provisions. Prevents exclusion of common law rights. Prohibits exemption clauses that waive implied guarantees or warranties. Items sold on credit cannot be sold voet stutes, as is. Suretyship Amendment Act, 1971, abolished a common law defense that previously allowed women sureties to escape liability. Rental Housing Act regulates landlord-tenant relationships, ensuring a balance of interests. Tenant protections. Deposit must be invested in an interest-bearing account. Landlord must provide receipts for payments. Refund of deposit within 7 days or 21 days after deductions. Certain terms cannot be excluded by agreement. Consumer Protection Act. Most extensive intervention in contract law. Introduces new implied terms and restricts exclusions of common law and statutory rights. Key takeaways. Implied terms operate unless excluded, except for protected statutory terms. Common law implied terms evolve and can be overridden by agreement. Statutory implied terms arise in areas where contractual power imbalances exist, for example, labor, credit, consumer protection. Courts and the legislature intervene to ensure fairness in modern contracts. Next page. Is an implied term just a rule of law applicable to a particular class of contract? Position in Alfred McAlpine and Son, Proprietary, Limited v. Transvaal Provincial Administration. Corbett J. An implied term is a standardized one, functioning as a rule of law applied unless excluded by agreement. Originates partly in contractual intention, but legal policy and other considerations also contribute to its formation. Harms D.P. A naturel is a rule of law that can be varied or excluded by agreement. Distinction in the Rental Housing Act. Chapter 3 of the Act distinguishes between 1. General provisions regulating landlord-tenant relationships, S4. 2. Terms deemed to be part of a lease agreement, S53. Theoretical and practical distinctions. Implied terms implied by law versus general rules of law. Implied term, ex lege, general rule of law. Forms part of a specific contract type, for example, lease employment, applies broadly to all contracts or specific contractual relationships. May be excluded by agreement unless expressly prohibited by statute. Cannot be excluded unless statute allows it. Standardized provision, applied unless varied binding legal rule, not dependent on individual contracts. Examples: duty to remunerate in employment contracts, landlord's duty to maintain property. Examples: common law rules on interpretation, good faith, and public policy limitations on contract terms. Practical implications. A rule of law applies generally to a class of contracts, guiding contractual relationships. An implied term operates within individual contracts, forming part of the agreement unless expressly excluded. Statutory provisions like those in the Rental Housing Act can create both. Rules of law applicable to all leases, for example, general tenant protections. Implied terms that automatically form part of lease agreements unless excluded. Conclusion. An implied term is not merely a rule of law applicable to a particular class of contract. Implied terms function as legal defaults within contracts, while rules of law govern contractual frameworks more broadly. The Rental Housing Act's distinction suggests that not all statutory provisions that regulate contracts create implied terms, reinforcing the theoretical difference between the two. Next page. 10. Read 3. Two terms implied ex consensu, tacit terms, definition. Tacit terms are not explicitly agreed upon, but are assumed to be part of the contract based on the parties' shared expectations. They function like express terms despite being unspoken. Determination of tacit terms. Derived from express terms of the contract. Circumstances surrounding the contract's formation. In some cases, courts may consider subsequent conduct of the parties. Key tests applied by courts. Officious bystander test. Hypothetical scenario where an impartial bystander asks whether a certain term applies. If the party's response would be an immediate and obvious yes, the term is implied. Covers terms the parties thought unnecessary to articulate and terms they would have agreed upon had they considered them. Business efficacy test, Reigate v. Union Manufacturing, Ramsbottom. The implied term must be necessary to make the contract effective, not merely reasonable or convenient. Adopted consistently by South African courts. Clear and exact formulation requirement, Technipac Sales Proprietary, Limited v. Hall. The term must be precisely defined. It must be so clear that it would evoke an immediate, unanimous agreement between the parties. Subjective intention consideration, 7-Eleven Corporation of S.A., Proprietary, Limited v. Cancun Trading No. 150 cc. Courts traditionally rely on objective criteria. Supreme Court of Appeal suggested subjective intentions might also be relevant. Tacit terms and trade usage. Trade practices may be incorporated tacitly if the parties both knew of and accepted the trade usage. One party knew of it, and the other could reasonably be expected to have been aware. Binding trade usages must be universally and uniformly observed in that industry, notorious, reasonable, and certain, not in conflict with law or the express contract terms, objective reliance principle. Even if a party was unaware of the trade usage, they may still be bound if they reasonably led the other party to believe they were contracting subject to it. _ 10.3.4 Material terms. Definition. Terms in a contract differ in importance. Material terms. Essential to contract performance. Breach allows the aggrieved party to cancel the contract. Non-material terms. Less critical to contract performance. Breach allows only a claim for damages, unless a cancellation clause exists. Examples of non-material terms. Payment and delivery terms are generally considered non-material. Consequences of breach. Late delivery. The aggrieved party must warn the defaulter and give reasonable time to perform before cancellation. Late payment. The supplier must demand payment first before cancelling and reclaiming goods. Next. Page 10.3.5 Conditions and their effect on the contract. Definition. A condition is a contractual provision that makes an obligation dependent on an uncertain future event. Unlike ordinary terms, conditions do not impose duties or confer rights directly, but determine what happens to contractual obligations, based on an event occurring or not. The key factor is whether the uncertain event will happen, not when it will happen. 10.3.5.1 Positive and negative conditions. Positive condition, affirmative condition. Obligation depends on an event happening. Example, I will pay your university fees if you pass all exams. The condition is fulfilled when the event occurs, i.e., if the student passes. Negative condition. Obligation depends on an event not happening. Example, I will pay your university fees unless I am dismissed from my job. The condition is fulfilled when it becomes certain that the event will not occur, i.e., when the fees are due, and the person has not been dismissed. 10.3.5 To suspensive and resolutive conditions. Suspensive condition, condition precedent. Obligation exists but is unenforceable until an uncertain event occurs. Example, A agrees to buy B's property, provided planning permission is granted. The obligation exists upon contract formation, but remains suspended until the event happens. Effects. If fulfilled, the contract is retrospectively valid as if it had always been in effect. If not fulfilled, the contract is void ab initio, as if it never existed. Pending fulfillment. A conditional right exists. It may be ceded, inherited, or secured, for example, suretyship. Resolutive condition, condition subsequent. Obligation exists but will end if an uncertain event happens. Example, a student receives funding for her degree, unless she fails an exam. Effects. If the condition is fulfilled, i.e., failure occurs, the contract terminates. If retroactivity applies, the contract is void ab initio unless continuing obligations exist. 10.5.3 Potestative, casual, and mixed conditions. Potestative condition. Fulfillment depends entirely on the creditor's actions. Example, a dealership donates a car if a golfer hits a hole-in-one. The golfer's action, hitting the shot, is entirely within their control. Casual condition. Fulfillment depends on an event beyond the party's control. Example, rent increases if municipal rates increase. The fulfillment depends on external factors, municipality decisions. Mixed condition. Fulfillment depends partly on the creditor's action and partly on external factors. Example, a wealthy uncle buys his niece a car if she obtains a driver's license. The niece must take action, but the licensing authority also plays a role. 10.5.4 Interference in the fulfillment of conditions. Doctrine of fictional fulfillment of a condition. A party cannot interfere to prevent a condition from being met. If they do, the condition is deemed fulfilled or not fulfilled, depending on the circumstances. Scott v. Poupard. Holmes J. If a party prevents the fulfillment of a condition to avoid obligation, the law treats the condition as fulfilled against them. _. 10. Re.6 Time clauses. Definition. A time clause, DIES, is a contractual provision that makes the operation of an obligation dependent on a certain future event or time. Unlike conditions, time clauses refer to a certain future event, not an uncertain one. Types of time clauses. Suspensive time clause. Obligation exists but is postponed until a specific time/event occurs. Example, a loan repayment is due on a fixed date. Resolutive time clause. Obligation terminates at a specific date/event. Example, a husband pays maintenance for a set period after divorce, but it ends on a certain date. Next page. 10.7 Other common contractual terms. Contracts often include additional terms that shape the rights and obligations of the parties. Some common terms include suppositions, modal clauses, exemption clauses, non-variation clauses, and governing law clauses. _. 10.3.7.1 Suppositions. Definition. A supposition is an assumption made by both parties about an existing or past fact. If the assumption is false, the contract may be void. If the assumption is correct, the contract remains valid. Key characteristics. The supposition must be shared by both parties to be legally relevant. If only one party assumes something, it is merely an error in motive and has no legal effect. Difference from conditions. Suppositions relate to past or present facts, while conditions relate to future events. Both may be express or tacit, and both introduce uncertainty, but they operate differently in contracts. _. 10.3.7 Do modal clauses, modus, definition. A modal clause is a term that imposes a future duty on the recipient of a benefit. Example, a donation of land on the condition that it must be used for a school. Key points. The obligation arises immediately upon contract formation. Failure to comply constitutes a breach of contract. Remedies for breach follow general contract law principles. _. 10.3.7.3 Exemption clauses, exclusion clauses or disclaimers, definition. Terms that exclude or limit a party's liability under the contract. Example, a hotel disclaims liability for guests' lost or stolen items. Key points. Generally valid and enforceable, unless they are contrary to public policy. Invalid if they attempt to exclude liability for fraud, intentional harm or injury. Further details. Exemption clauses are analyzed in greater detail in other sections of contract law. _. 10.7.4 Non-variation clauses. Definition. A term specifying that contractual variations must be in writing or that no variations are allowed. Example, a lease requiring all amendments to be in writing. Key points. Oral variations are generally ineffective if a non-variation clause exists. Such clauses are valid and enforceable. Further details are explored in Chapter 6. _. 10.7.5 Governing law clause. Definition. A clause specifying which legal system will govern the contract. Common in cross-border agreements. Key points. Generally valid and enforceable, but subject to limitations. Choice of law governs. Intrinsic validity. Effect. Interpretation of the contract. Limits on choice of law. Does not affect contractual capacity, formal validity, or legality. These are governed by the objectively applicable law. Cannot override mandatory provisions of the law with the closest connection, for example, consumer protection laws. Absence of a governing law clause. If no governing law is chosen, the contract is governed by the legal system with which it has the closest and most real connection.